Hello. Huh?
Sir, you can come in.
Hello, sir, namaste.
I don't want Chris to always unmute me, so I'm going to allow. I'm going to join the meeting.
Hello. Madam, on 5 minutes ನಾನು ಆಫೀಸ್ ರೀಚ್ ಆಗ್ಬಿಡ್ತೀನಿ.
Okay, sir. Okay.
Join with computer audio.
ಎಲ್ಲಾರನ್ನು ಮ್ಯೂಟ್ ಮಾಡಿರ್ತೀನಿ ಸರ್ ಹಂಗ.
So Chris, the host, comes in.
Hello,
Y'all know where
sir?
this is, the host. Mute all. In the bottom left corner, notice it says mute.
So you keep this order and ask what you do is ask Ravi Gowda to once a while from civil code. Okay, not civil code. From Vidhan from UBCT. Okay, from UBCT. How far is it from UBCT? Okay, then once a while ask Ravi Gowda. Suppose if the board is not removed, ask Ravi Gowda to visit the property once a while just to see whether the board is there or not. If it is not there,
that we have a relative who can do that for us.
then it's better.
No, we can go and see now.
नहीं आगे चलिए by chance उसने कल नहीं निकाला
आज अगर नहीं निकाला then we'll do something.
Okay.
Then we'll do our.
Yes, I think sir, this is for your office because he's given me 2 copies already.
You can keep it. See, we don't need any
You don't
certificate
need
copies. Original, we don't need. As many originals are there, you keep it.
Okay.
We don't need the original. Nitin, bah.
इनका ऑनलाइन ट्रांसफर का डिटेल्स आपके पास है.
If you pay cash, there is nothing like that. I'll be saving another 30,000.
Sir, can he pay you 70,000 cash? If you are saving that much.
Sir, please. माफ भगवान करके.
आपने बोला sir.
भगवान करके. I know my
आपने बोला
my
sir.
chartered accountant will somehow save that money also. भगवान करके
But
पूछ
you said sir. I didn't say that.
This
I'll
is-
happily pay you. That
You're
is the case.
unbelievable people. I don't know. With this argument, if you address people, Sunil, I think you would have succeeded. What is his name? Anil? I always give. You are Sunil. So this much argument, if you address to him every day, I think. Mr. Korimat, sir? Mr. Kantra, sir? One ನಿಮಿಷ. Mr. Kantra, sir, video on ಮಾಡ್ಕೊಳ್ಳಿ. Yes, sir, only 1 second. Unmute ಮಾಡ್ಕೊಳ್ಳಿ, sir. ಕಾಂತ್ರ ಸರ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಸರ್ ವಿಡಿಯೋ ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ಹಲೋ
Yes, sir. Yes, sir. Only 1 second. Only 1 second.
So is it all right now?
Yes, sir. Yes, sir. Yes, sir. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಮತ್ತು ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಲಾ ಅಕಾಡೆಮಿ ಇವರ ವತಿಯಿಂದ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಧೀಶರ ಮುಖ್ಯ ಪರೀಕ್ಷೆಗಳ ಬಗ್ಗೆ ತರಬೇತಿ ಶಿಬಿರವನ್ನ ಇಂದು ಯಶಸ್ವಿಯಾಗಿ ಮುಂದುವರಿಸಿಕೊಳ್ಳಲಾಗುತ್ತದೆ. ಇವತ್ತಿನ ಸ್ಪೀಕರ್ ಶ್ರೀ ಎಚ್ ಕಾಂತರಾಜ್, ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್, ಹೈಕೋರ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ. ಸೊ ಇವರು ಕೊಡುವ ಭಾಷಣ ಮತ್ತು ಲೆಕ್ಚರ್ ಅನ್ನ ಕೇಳಿ ತಾವು ಇನ್ನೂ ಹೆಚ್ಚಿನ ರೀತಿಯಲ್ಲಿ ಯಶಸ್ಸನ್ನ ಕಾಣಲಿ ಅಂತ ಹೇಳಿ ಆಶಿಸ್ತಾ ಇದ್ದೇನೆ. ಸೊ ಪ್ಲೀಸ್ ಟೇಕ್ ಓವರ್ ಸರ್. ಸರ್ ತಾವು ಶುರು ಮಾಡಬಹುದು.
Good evening to everybody. At the outset, I would like to thank the Law Academy Karnataka State Bar Council for having given me this great opportunity to have the interaction with my advocate colleagues, maybe throughout the state. And now, today's subject, as it is mentioned by the President Sri Basuraj, the Specific Relief Act 1963. It's a very interesting enactment, and I must also share with you how I developed my interest so far as this enactment is concerned. Maybe some little introduction or history of the enactment is necessary for the purpose of understanding the Specific Relief Act 1963. See, when I was working in my senior's office, Sri N.Y. Mantappa, as a junior lawyer, my senior asked me to look into the provisions of the enactment and some issues. Then I took the enactment and saw the provisions, starting from the title of the enactment. So, as it is now mentioned, it was 1963. A doubt arose to me as to how this enactment is called 1963. Was there no enactment called a Specific Relief Act earlier to 1963? We got independence in 1947, Constitution 1950. How this could be 1963? What was the position earlier to that? Then I came to know that this act was replaced. Earlier to this also, Specific Relief Act was in India. It was, say, used for the purpose of deciding the cases also. Then it was, I found it was of 1877. That is, the Specific Relief Act of 1877 was earlier to 1963 enactment. Then another question was how this became 1963 from 1877. So that is how, see, I went on examining the matter.
Sir, your voice is not audible. Hello, sir. Hello, sir. Sir, your voice is not properly audible. Sir, ಬಹುಶಃ ನಾವು ಹೇಳುವಂತದ್ದು ಈಗ ಅವರ ತಾಂತ್ರಿಕ ತೊಂದರೆಯಿಂದಾಗಿ ಅವರ ವಾಯ್ಸ್ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಆಗ್ತಾ ಇದೆ. ಕೆಲವೇ ಕ್ಷಣಗಳಲ್ಲಿ ಅವರ ಆಡಿಯೋ ಬೇರೆ ಕ್ಲಿಯರ್ ಆಗ್ಬೋದು. ತಾಂತ್ರಿಕ ತೊಂದರೆಯಿಂದಾಗಿ ಗೌರವಾನ್ವಿತರ ಧ್ವನಿಯಲ್ಲಿ ತೊಂದರೆ ಆಗಿತ್ತು. Sir, unmute your voice, sir. Sir, unmute your voice. Thank you, sir. Thank you.
Is it all right now?
Now it is okay, sir.
Okay.
It is audible.
Thank you. So I was telling about the history of the enactment, that is the Specific Relief Act 1877. See, in India, first law commission was appointed in the year 1834, before the independence, when Lord Macaulay was heading the law commission. He made a recommendation or made an observation also to the effect that substantially the law in existence in England is to be adopted so far as the Specific Relief Act is concerned in India. So therefore, till we get the constitution, so we had the law that is called as the Specific Relief Act 1877. So the law in England, which was prevailing in England, was adopted in India. So this was there till 1963. 1963 Act came into force in the year 1934 after the recommendation made by our law commission, that is in the 9th report of the law commission, which was appointed in India for the first time subsequent to the constitution. So after the independence, it was reviewed and considered to be the Specific Relief Act 1963 by certain amendments. See, earlier to this, now the 1963 Act, now we are dealing with it and we are using it also. The difference between 1877 and the present enactment 1963 is, under the present enactment, there are 7 reliefs under the enactment. 3 parts, 7 reliefs are there. And section 40, the act containing only section 40. See, the difference between 1877 and 1963 enactment is, earlier under 1877, in addition to the existing provisions of law, we had the provisions so far as the appointment of receiver under the same enactment, also the enforcement of public duties. These 2 remedies were also under the 1877 enactments, and after 1963, so these were removed from the present enactment. So now, as you all know, so far as appointment of commissioner is concerned, it is under the CPC under Order 40. And so far as enforcement of public duties are concerned, I think that is included under now the constitutional duties under Article 51 capital A, as you all aware of the same. So now, excluding those 2 remedies, now we are dealing with as it is under 1877 enactment, all the provisions are there. Now the interesting thing is, the Specific Relief Act deals with only specified remedies which are coming within the purview of the not coming within the purview of the common law or common law courts. So therefore, they are called as specific reliefs. So provided under this enactment. And why see, I am making it very clear, kindly note that. So these are the remedies. These are the remedies based on equitable principles. Equitable remedies. The remedies provided under the specific relief act, are called as equitable remedies, equity. So what is equity? See, equity is fair, ethical, equity. See, in other sense, it is called as, we can call it as dharma also. So something, so beyond law, according to me, even beyond law, you may have to exercise some discretion for the purpose of granting the reliefs. So we always write in our applications before the court and also in the petitions, including the pleadings in the civil court, saying that so relief may be granted in the interest of justice and equity. See, what is the meaning of equity? How this arose? Why we call these as equitable remedies? So there is also an interesting thing here. So in England, there are there were earlier two types of courts. The common law courts and equity courts. Once so happened, Chief Justice Lord this time. Edward Coke, he was heading the King's Bench. So there were common law courts and equity courts. Or equity courts are also, they were called as the Chancery Court. So once there was a conflict between common law courts and equity courts. Common law courts were delivering the judgments based on the law that was in existence. Once Chief Justice Edward Coke granted a decree. Later it was turned out to be, decree was obtained by fraud. So that man, went before the Chancery Court. Chancery courts are nothing but ministerial, courts. Later they were considered as, courts also. So Chancery Court was headed by Ellis Murray, one justice, Lord Ellis Murray. So Ellis Murray granted an injunction order saying that that decree granted by Chief Justice the King's Court should not be executed at all. So certainly, when the order was passed by highest court, King's Bench, how could Ellis Murray, the Chancellor, grant an order of stay or injunction, whatever it is, saying that it should not be, it is not executable or cannot be executed? So then the Chief Justice Coke wanted to take action against Ellis Murray, the Chancellor. Was it your jurisdiction to grant an order of stay or to say that it is not executable when the highest court has passed an order? On what basis you have passed the order? So then Ellis Murray said, so it is based on the principle of equity. I have granted. Then what is the equity and all those? Then the conflict was referred to the then Advocate General by name Bacon, who later became the Justice in England. Then conflict was referred to then Advocate General, Attorney General. Finally the decision was in favor of Chancery Court only. So they took a decision saying that wherever the remedy is not available or wherever the remedy is not adequate, so then the adequate in the common courts, so those remedies were granted by the Chancery courts on the principles of equity. equity. So therefore, they were called as, say, equitable remedies, and the based on the principle of equity. That is how these provisions under the Specific Relief Act are also so based on equities. Therefore, we call these are equitable reliefs. So the remedies are being granted is solely or substantially based on the principle of equity, discretion. So how that is, the discretion is to be exercised, all these things are to be looked into by going to the provisions of the enactment. Now coming to the Specific Relief Act of 1963. Now we have come to know how 1870, what was the position earlier to 1963, and how this became 1963, and they came into effect in the year 1964 after passing a resolution by our parliament. So this is in force since 1964. That is 1/3/1964. This act is in force. Now, let us see the scope of this enactment. So I request my friends to understand this enactment, while referring to the contract law also, because it has been made very clear under the enactment, saying that whatever the meaning that is provided under this enactment is to be taken as the meaning under this enactment. But wherever the definition is not provided here for the expressions provided under this enactment, the definitions referred under the or given under the Contract Act are to be taken into consideration. So therefore, both the enactments go hand in hand, and principles are applied under this enactment also, so far as the Contract Act definitions are concerned. So now the important thing is here, what are the kind of reliefs that are provided under this enactment. As I mentioned earlier, so there are 7 reliefs under the enactment, specific reliefs under this enactment. That is the recovery of possession of the property, and specific performance of the contracts, and then a rectification of instruments, and rescission of contracts, cancellation of instruments, and then declaratory decrees, and then lastly, preventive remedies, that is preventive reliefs. Now it has been stated, in this enactment itself, why I refer to the history of the enactment is this. It has been said that whatever that has been said under the enactment, Specific Relief Act, is not exhaustive. That is what our Supreme Court says, and our Karnataka High Court also says in the year 1951. So this basically based on the law that was in existence in England, or English law. So therefore, wherever the problems arise under this enactment, and there is no answer for that till now, then for the purpose of resolving that issue, so our Supreme Court says in the year 1972, and Mysore High Court says in the year 1951, saying that the law that is in existence in England can also be referred to for the purpose of resolving the issues involved in this enactment. So that is what our Supreme Court says in the year 1972, affirming or accepting the judgment of our Mysore High Court. So with this background, we say. So now coming to the Specific Relief Act all these remedies, kindly underline, these are the basic principles. All these remedies are civil remedies under the enactment. Whatever remedies that we get under the enactment, they are all civil remedies. So they are not, provisions does not deal with the penal law. We must there is a clear demarcation, a clear distinction, saying that we know what is civil law and penal law. So there is, penal law is nothing but a civil law, which provides for punishments. So this deals with only the civil laws, civil remedies. And then whatever decision given by the specific relief under the specific relief act by the competent courts, they are the judgments or the decision in person and not in rem. So whoever comes to the court will get the relief. So see, these are the basic principles. See, under the specific relief act and the provisions provides for. See, and then you see one more aspect, basic principle. Another aspect is that we must understand. See how these provisions are to be implemented and understood for the purpose of resolving the disputes in these matters. See, the principle is, you please note, you do for which you are agreed. You do as agreed. Your promise. This is the principle. You do as agreed is the principle so far as the reliefs under the enactment are concerned. That means, see, you do as agreed means your promise to do something, you please do it. If you don't do it, so then the remedy lies before the competent court of law dealing with the provisions of this specific relief act. That means you do as agreed is the general principle so far as the specific relief act is concerned. That is the basic principle. So based that on only, see, wherever we go to the court, even for anything for specific performance, we always say he had agreed for this. This was the agreement. These were the terms which have not been completed, which have not been performed. So therefore, we have come to the court. Therefore, I am saying these principles are based on the saying that, quoting, you do as agreed is the principle. So while implementing all these ideas, there are certain definitions under the enactment. Very few definitions. I have already made it very clear, except the definitions already provided under this enactment under section 2. See, all other meanings for the purpose of resolving the issue is to be, the definitions provided under the Contract Act. So here it is provided as a definition, coming to definition clause, that is the obligation. Obligation is the thing, but duty cast upon a particular person or particular authority. So obligation is to be implemented, or you abide by your duty. So that is the definition. See, and then settlement, if there is any settlement between the parties, that is to be how it is to be resolved. It is between the parties, and agreed person will have to go to the court of law for the purpose of getting it implemented. If there is already settlement, what is settlement is also defined here. And then trust and trustee, and then lastly it is provided saying that all other words and expressions used herein but not defined in the Indian Contract Act 1872 have the meanings respectively assigned to them in the Act. So therefore, according to me, this enactment and the Contract Act go together. We have to understand the principles, that is common principles underlined on both enactment. Now coming to the remedies, the specific remedies provided under the enactment, very, very importantly, chapter 1, that is part 2 deals with, part 1 deals with the definitions. As I mentioned, only 4 to 5 words have been defined: obligation, trust, trustees, settlement. These are the definitions. Other definitions are to be understood as provided under the Contract Act. Now, coming to this provisions, that is chapter, particularly chapter 2 is very, very important. Chapter 1, that is part 2. That is recovery of possession of, the immoral property, section 5. See, I already mentioned this enactment deals with, only civil rights or, not enforcement of penal laws. So now we're coming to taking possession of the immovable property is concerned. Act provides under Section 5. What is the remedy open to that? Now you know what is immovable property: land, house, etc. So how to recover the possession of the immovable property? So there is some immovable property which has been, in my possession for a long time, or maybe for quite some time. So I have been dispossessed. Forget about the fact about the ownership or the title of the property. But fact remains that I am in possession. I was in possession. Now I have been dispossessed. Then see how to recover it. See, kindly don't forget, I have already mentioned, wherever the remedy is not adequate, wherever the remedy is not adequate in the common law courts or regular courts or provided under the specific relief act, courts or the courts which are dealing with the specific relief act. So here we are talking about the recovery of possession of the property. So under Section 6 provides of the Act provides the recovery of the possession of the property. That's all. It does not say the recovery of the possession by the lawful owner or the person who holds the title, but it says only recovery of the possession of the property, immovable property. So here what is interesting is whether you are owner or not, whether you are having title over the property or not. If you prove that you are in possession and dispossessed by anybody, then specifically fact says what is the remedy available to that person under Section 5 and 6. I will come to 6 later. Section 5 says the person who was in possession is entitled for restoration of his possession if he has been dispossessed in the manner not known to law, only by proving that you are in possession before the dispossession. So therefore we say even person who is in unauthorized occupation is also entitled for protection under law. That is the principle underlined under the Section 50, Section 5. Because carefully, you please read once again, there it says recovery of possession of immovable property. So under those circumstances, you have been dispossessed from the immovable property, you are entitled for the restoration if you prove only two things. One is you were in possession of the property and then you were dispossessed in the manner not known to law or arbitrarily or forcefully. Then remedy lies to such persons to file a suit for recovery of possession and establish that you were dispossessed illegally. So under those circumstances, Act provides for remedy of restoration of the land that was in your possession. But that does not mean that the defendant is not entitled for other remedies. Court will come to our rescue saying that plaintiff has been dispossessed from the property in the manner not known to law, so therefore he is entitled for the possession. The defendant will take a contention saying that, no, I am the owner of the property, I dispossessed him. Plaintiff is not the owner, then court will not agree with him, saying that, all right, you may be the owner, but you ought to have evicted him, ought to have dispossessed him the property in the manner known to law, but you have not followed the procedure underlined under the law. So therefore, first you give the possession back to the person, that is the plaintiff. Later, other things would be decided by the competent court. So therefore, what I am saying, the moment you take the possession or restoration of the possession as per section 5 of the Specific Relief Act, that will not prevent, that decree will not prevent the real owner, that is the defendant, from filing another suit for possession based maybe on title. But first thing is, section 5 provides for taking back the possession, the person who was in possession of the land earlier to dispossession. This is the protection given under section 5 of the Specific Relief Act. And then who it to be obtained, that relief is provided under section 6 of the enactment. So section 6 provides two conditions for the purpose of taking back the possession. That is, one is if you are dispossessed. If necessary, I will also use Kannada. So because maybe necessary for some times, wherever it is necessary, so I will also make use of Kannada also for the benefit of everybody. But coming to section 6 now, section 6 says how to implement section 5. So section object of section 5 and section 6 are one and the same. But section 6 says how to implement section 5, how to get the relief section under section 5. Section 6 says imposing two conditions. That is, one is if you are dispossessed for restoration of the possession, so you must file suit within 6 months. And then if you are dispossessed by the government, you cannot file a suit at all. These are the two conditions, specific conditions provided under section 6. Now, if you don't file the suit within 6 months, because this is a special enactment, there is a special another separate enactment that is called Indian Limitation Act. But here section 6 itself provides for limitation for the purpose of filing the suit for those who have been dispossessed from the immovable property. And then if you are dispossessed by the government, you cannot file a suit at all. These are the two conditions under section 6. This is how section 5 and section 6 are to be used for the purpose of getting back the possession from which you were dispossessed. Here another very interesting thing to be noted is, we all know that wherever the original court has passed the decree or an order finally, that is always subjected to, in our hierarchy, appeal, second appeal, revision, review. All these are remedies are provided for. But what is the position so far as section 6 is concerned? Section 6, under section 6, it has been made very clear that if a decree is passed that is not appealable, very peculiar, it looks to be very peculiar. So no appeal is provided against the decree provided under section 6 of the Specific Relief Act 1963. That is, it is the wisdom of the legislature, but according to me, appeal ought to have been provided because there is a difference between. So here, though appeal is not provided, but revision is provided according to our own High Court judgment. To give judgment later, but I will refer to that in the year 1994. This judgment came saying that appeal is not available so far as the decree under section 6 is concerned, only revision is available. So according to my personal opinion, see, if the appeal is not provided, you know the difference between the deciding of say revision, scope of revision and appeal also. In the appeal, particularly first appeal, we know that say that will be reappreciation of nothing but the original proceedings. But so far as a revision is concerned, the scope of the matter for the purpose of adjudication revision is entirely different, and it is very, very narrow when compared to appeal. So in the revision also, so what is that we can urge? Error of jurisdiction. If it is say opposed to law, then that is all the scope of revision. You can't say request the court for reappreciation of the evidence at all. So anyhow, as of now, the law remains against the judgment and decree under section 6 of the Specific Act. Only the original jurisdiction and then revisional jurisdictions are available. So this is how the recovery of possession is provided under the Specific Act so far as immovable properties are concerned under section 4, under section 5 and 6 of the enactment. And against that decree, only revision is provided. So not appeal. And then same, what is the procedure provided for the recovery of the immovable property is also the same procedure so far as the movable properties are concerned, so far as sections 5 and 6 are concerned. Same has been adopted. So now, this is the one of the remedies that are available under the Specific Act. That is regarding the possession, taking back the possession of the immovable property. So what would be the position? Say if it is a property of the private person, and if it is a property of the government, and if it is dispossessed by the government. So that is how. So this equitable remedy is provided by the competent court under the Specific Relief Act. See, after the recovery of the both procedure for recovery of the possession of the movable and immovable properties. Now, see the liability. Liability of the person possession, act as owner, deliver persons entitled to immediate possession. See, whatever that is provided for the movable properties, as I said, apply to the immovable properties also procedure. And then what is the specific defense available in the suit for specific performance of contracts? So here, precondition is there must be some agreement or contract. I said already saying that you do as agreed. So wherever the contract failure of the implementation of the contract, then conflict would arise, then a question of going to the court of law would arise. So whenever the aggrieved party go to the court of law, so Specific Relief Act, so what is the remedy that was available? As I've already said, so if the defendant is in fault, so then the court will pass a decree. Then what is the remedy that was available so far as the defendants are concerned? See, the defendant cannot as we already said, he is at the default. So therefore, plaintiff has gone to the court of law. He cannot deal with the defense. Anything other than the terms agreed under the enactment, under the contract. That is the terms of contract. See, it is not open for him to say anything other than the terms agreed under the contract. See, now, cases which specific forms of contract enforceable, when can be specifically enforced? Obviously, the contracts which are in accordance with law, or the understanding under the agreement which has been entered into according to law. Otherwise, they are not enforceable. That is what the section 10 says. Here, very important aspect is, so what are the contracts that are enforceable under law? That means, so we have understood under the Indian Contract Act, say what are all the contracts which are valid, which are void, which are voidable. The contracts which are according to law are valid. The contracts which are not, in conformity with law are void. Contracts which are yet to be declared as void or valid are voidable. Till a competent court of law says that it is invalid, so that voidable contract is valid. You all know. That is the difference between void and voidable contracts. So here, what I'm saying is, so valid contracts, the contracts which are enforceable in the court of law under the specific factor, the valid contracts. Valid contract means it must be between the two parties, between parties who are competent to enter into the contract. Competent person means he should not be a minor, insane, etc., etc. That is, who is competent to enter into contract. We have all also understood both under the Contract Act as well as under the Specific Fact. So valid contracts only are enforceable in the court of law under the Specific Effect. So far as section 10 is concerned. Otherwise, so they are not valid. You also know sometimes, valid contracts means what? Again, we'll come to that. I will give an example. Suppose there is an agreement between the two parties for the purpose of performing some act favorable to them, or which was in need so far as those two parties are concerned. I will give you an example. We had the Fragmentation Act. Under the Fragmentation Act, there was a provision saying that so small bits of land should not be alienated. Person should not it is prohibited. Rather, it is prohibited from alienating the small bits of lands, maybe 2 acres or less than 2 acres. That is the law of the land now. It is in existence now. When such being the case, if you enter into, I am giving this an illustration. Such being the case, such being the law, if you enter into a contract to purchase, what is prohibited under different law or another law, then even though the contract or the agreement entered into between these two parties, though they are competent, consideration is passed between the two major persons, everything is all right. Both of them have signed it also. But is it a valid one? Under those circumstances, if the other party is not prepared to give the sale deed, then aggrieved person or the purchaser can go to the court of law. But will court grant the specific relief, relief or the decree for the purpose of executing or for the purpose of performing this contract? No, because though there is a contract between these two persons, plaintiff or the defendant, court will not grant because this agreement itself is void. Because it is against the existing law, which law, say, where law prohibits, the sale transaction. So therefore, this is the difference. And another example also to understand this provision of law I can give, saying that, see, there is an agreement in respect of 5 acres of land for the purpose of putting up a say factory for manufacturing illegal or manufacturing some arms and ammunitions, whatever it is, which is not permitted under law for a private person without any license or without any support of law. Even though there is an agreement to that effect between the parties, but court will not recognize it because it is prohibited. So therefore, for the purpose of getting the relief under section 10 of the enactment, enforceable contract is necessary. That means it must be a valid one. Whatever that is required to call as a valid agreement or valid contract, so that is the requirement of, say, enforcement of contract before the court of law under section 10 is concerned. Otherwise, it is not. What is condition precedent is there must be a contract and it must be a valid contract to say that it is enforceable before the court of law. So that is what section 10 says under the specific effect. And then say, in addition to valid contract, say what is another aspect is, say, if you don't have the adequate remedy elsewhere, as I said in the beginning itself, these are the remedies provided wherever there is no adequate remedy. Suppose it's a matter to be settled between the parties by paying money and money alone sufficiently without any injustice to any one of the parties. That will not come within purview of the Necessity Act. So earlier to this enactment, for your information, you all know, say, that before this enactment, this Specific Act, even maybe say 1877 enactment, the procedure that was provided is you pay compensation. There was no remedy for the purpose of recovery the property as per the terms of agreement. So here, this is added. So if the remedy is not adequate, compensation only by way of money is not, termed as or understood as adequate remedy in the given circumstances. So then court will have to come to know or decide whether this person is entitled for the land and land alone as per the agreement, or in lieu of that he is entitled for the compensation, or land as well as compensation, or only the money that he has paid, maybe with interest or without interest. So all these aspects will be decided in the specific effect under this provision. All that he has to show that there was an agreement which was in accordance with law, that is valid agreement, and and he had no adequate remedy except coming to the court of law for the purpose of the loss he has incurred or likely to be incurred if it is not implemented. So this is how the remedies are provided under the enactment. So Specific Act provides for the persons, those who do not get the adequate remedy elsewhere, he can come under this provision, and this is how the Specific Act provides relief for that person. So coming to this valid contract, how it is to be filed. see, can that see the section 12 deals with the specific performance of part of contract. Is it permissible? See, part of contract, not possible in instant case. Whatever remedy that can be provided, see, that can be provided in toto, not in part. Either you give the land as agreed, give the house as agreed, or you pay the amount back with interest. So there is no part performance of so far as the contract is concerned. Then so far as the title is concerned, little difference is there. I will come to that. But here, so general principle is that the contract in toto is to be enforced in the court of law, and contract will either this way or that way. So that will be in the finality of the agreement that is entered into between the parties after the examination as to its validity and enforceability is concerned. As I said, the relief is only in respect of person. That is person, I have already said, against the defendant, only in favor of the person who has come to the court or who is entitled for relief. Maybe they may dismiss the suit or decree the suit. That's a different matter. But in its entirety, that will be examined and relief will be granted by the competent court. So there is no part performance so far as the specific performance of contract is concerned. And then what are the rights of persons against the seller who has no title at all? That is what section 13 deals with. So you enter into a contract with a person. Well, of course, he will disclose, saying that he will say at the time of agreement or entering into contract, I am the owner, sir. I have got all rights over the property for the purpose of enjoying as well as disposing of the property. So if you are interested, you purchase. Believing his words, this man will enter into a contract. Agreement to sale. And the seller will not ultimately agree to execute the sale as agreed under the agreement to sale. Then the purchaser will have no alternative but to approach the court of law for the purpose of relief as per the contract. Later it was found that the person who came to sell the property had no valid title over the property. Then what is open to the plaintiff or the agreed person? Agreed person will become plaintiff and he will have to go to the court of law. The Act provides certain protections to the purchaser under those circumstances. So if he does not have the title, for that moment he will not have any relief at all. But very interesting aspect here in this case is if there is a subsequent development of that defendant acquiring the valid title over the property for which he had entered into contract, though he had no title, valid title over the property earlier at the time of contract, the plaintiff would get the right over the property. Court will come to your rescue, though he had no title over the property at the time of entering into a contract. Now he has subsequently acquired, or even court may say that a defendant, if he acquires title over the property, valid title over the property, so that will inure to the benefit of the plaintiff. That is the protection provided under section 13 of the Specific Relief Act. The plaintiff will not lose his right over the property subsequent acquisition of valid title over the property by the seller would inure to the benefit of the plaintiff, though the defendant had no title over the property at the time of contract. So this is the protection. So that will not end for the defendant to say, I had no title over the property. Even then, we lawyers who are all appearing for the plaintiff, so we'll have to make a research. We'll have to ask his party to find out whether subsequent to the contract, whether he has acquired or title over the property or not. If you make a research and efforts, tomorrow you may come to know that he had no right, at the time of contract. Subsequently, he got the property, right came to him. Therefore, I will also get the right over the property. Then definitely the plaintiff would succeed under those circumstances also. So this is how it has been provided relief under the specific so far section 13 is concerned. So rights of the purchaser are crystallized even after the acquisition of the title by the defendant, after some time, after even subsequent to the contract. That is the crux of the matter. Or any person for that matter, the mode of acquisition of title by the defendant, anyway it may be, even the person who has purchased the property or subsequently or under the name of the defendant only, then court will also compel him to give the possession. You know that subsequently I will come to that subsequent purchaser, that is there under section 19. So therefore that protection is given to the purchaser. So if there is no title to the defendant initially and subsequently acquires. And then coming to the another incident, which are not contracts not specifically enforceable. As I have already said, contracts which are valid under law are enforceable. Specifically, if there is an example, I will also go. What are all the contracts that are not specifically enforceable? For example, we enter into a contract or agreement with some other person in respect of the minor's properties. So, if there is no dispute with regard to the fact that the property belongs to a minor, and if you enter into a contract with respect of that property, which lawfully belongs to the minor, can such a contract be enforced? So those are all the circumstances under section 14 of the special fact where you are entitled for the relief if it is enforceable or which is not specifically enforceable. And if it is a contract entered into, entered with a person who is unsound mind, who is competent to enter into contract at all, contracts which are not in accordance with law, prohibited under law. So these are all the contracts which are not enforceable in the eye of law. So under these circumstances, if a client comes to us saying that, sir, you file a case, fact reveals. ನಾವು ಚರ್ಚೆ ಮಾಡ್ಬೇಕಾದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಏನಂತ ಇದು ಮೈನರ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳಿ. ಆಗ ನಾವು ಏನ್ ಅಡ್ವೈಸ್ ಮಾಡ್ಬೇಕು ನಮ್ಮ ಪಾರ್ಟಿಗೆ? ನಾವು ಇಲ್ಲಪ್ಪ, ನೀವು ಕಾಂಟ್ರಾಕ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರು ಕೂಡ ಇದು ನಾಳೆ ವ್ಯಾಲಿಡ್ ಆಗೋದಿಲ್ಲ, ಇದನ್ನ ಕೋರ್ಟ್ ಮೂಲಕ ಇದನ್ನ ನಾವು ಜಾರಿ ತರಕ್ ಆಗೋದಿಲ್ಲ, ಕಾನೂನು ನಮ್ಮ ರಕ್ಷಣೆಗೆ ಬರೋದಿಲ್ಲ, ಕೋರ್ಟ್ ನಮ್ಮ ರಕ್ಷಣೆಗೆ ಬರೋದಿಲ್ಲ ಅಂತಕ್ಕಂಥ ನಾವು ಅಡ್ವೈಸ್ ಮಾಡ್ಬೇಕಾಗುತ್ತದೆ. ಇನ್ನೂ ಒಂದ್ ಹೆಜ್ಜೆ ಹೋಗಿ ನಾವು ಮುಂದೆ ಹೇಳ್ಬೇಕಾಗುತ್ತೆ. ಒಂದ್ ಪಕ್ಷ ನೀವು ಡಿಗ್ರಿ ತಗೊಂಡ್ರು ಕೂಡ, ಜಡ್ಜ್ಮೆಂಟ್ ನಿಮ್ ಪರ್ವ ತಗೊಂಡ್ರು ಕೂಡ ಮೈನರ್ ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ, ಸೊ ಮೈನರ್ ಅವನು ಮೆಜಾರಿಟಿಗೆ ಬಂದ ಮೇಲೆ ಅದನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಸ್ಬೋದು ಅಂತಕ್ಕಂಥದ್ದನ್ನ ಹೇಳ್ಬೇಕಾಗುತ್ತೆ ನಾವು. ಸೊ ಇಂಥ ಒಂದು ಕಾಂಟ್ರಾಕ್ಟ್ ಗಳನ್ನು ಸ್ಪೆಸಿಫಿಕಲಿ ದೇ ಆರ್ ನಾಟ್ ಎನ್ಫೋರ್ಸಿಬಲ್. ಕಾಂಟ್ರಾಕ್ಟ್ ವಿತ್ ಮೈನರ್, contract with unsound man, contracts, see, which are prohibited, contract in respect of certain things which are prohibited under the, specified law. They are not specifically enforceable under the under the specific fact. Before the courts which are dealing with these remedies. So these are the provisions, provided, under the, enactment. Even, contract we all know. Contract we all know. Even under the Contract Act, there are so many types. Two types of agreements. Oral agreements are there, written agreements are there. Both are enforceable, provided, oral agreements we know, it is very difficult to prove. Even if you are capable of proving it, even it is also valid. And so far as the construction of the contract agreements are concerned, we lawyers particularly, while advising the parties, we must be very careful. In fact, on another occasion, a dispute arose. Contract means it's an agreement between two parties. Agreement is there. Only the seller has signed the agreement and not the purchaser. Can the purchaser go to the court of law for enforcement of such an agreement or contract? Of course, there are different opinions also, but ultimately, a very convincing reasoning, judgment is that it all depends upon the contents of the contract agreement. If there is a recital in the agreement saying that this document is valid, this contract is valid, only if both the parties to this agreement or contract sign this document, put their signature to this document. If there is such a condition under the agreement or term under the agreement that both should sign, then if one party has not signed, that is not a valid document. If there is no condition at all so far as that is concerned, if the seller has put the signature, so then that document is valid. Purchaser need not. Ultimately, who is conveying the property? It is seller who is conveying the property. And Madras High Court said, ultimately, so if seller has signed it, is all right, unless there is a condition to that effect that both the parties will have to sign. See, all these aspects for the purpose of getting these remedies under the enactment, very, very important. And particularly we lawyers must be very careful while drafting or finalizing these documents. Tomorrow that contract should be valid and it is enforceable in the court of law. For the purpose of saying that it is enforceable fully before the court of law, all these requirements are important. After all, the clients who do not know anything about the law or how these contracts are being enforced in the court of law, how it is to be proved, are not known to them at all. For most of the clients, maybe so many people are there, we are very well aware of all these aspects. But those who do not know must be guided properly. That is our obligation also as lawyers and advocates. And then this is how it provides for. And then coming to another aspect is who can go to the court of law Now we see we have dealt with say agreements, contracts which are valid, which are not valid, enforceable. How it is say voidable, and all those things. Then ultimately, if that agreement is not implemented, if any one of the party is not prepared to perform his part of contract, ಅವನು ಏನ್ ಮಾಡ್ಬೇಕು ಅದನ್ನ ಮಾಡದೇ ಇದ್ದಾಗ, ಯಾವ್ದಾದ್ರು ಒಂದು ಪಾರ್ಟಿ ಮಾಡದೇ ಇದ್ದಾಗ, ಸೊ ಅಗ್ರೀಡ್ ಪಾರ್ಟಿ ಅಥವಾ ತೊಂದರೆ ಆಗಿರ್ತಕ್ಕಂಥ ಪಾರ್ಟಿ ಏನ್ ಮಾಡ್ಬೇಕು? ಸೊ ಯಾರು ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕು? ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಇಶ್ಯೂ ಅಲ್ಲ. ಈಗ ಅದು ಸೆಕ್ಷನ್ 20 ನಲ್ಲೂ ಕೂಡ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ, ಅದಕ್ಕೆ ನಾನು ಬರ್ತೇನೆ. ಸೊ ಈಗ ಅದನ್ನ ಯಾರು ಹೋಗ್ಬೇಕು ಅನ್ನೋದನ್ನ ನಮ್ಮ ಸೆಕ್ಷನ್ 15 ನಲ್ಲಿ ಹೇಳುತ್ತೆ. ಸ್ಪೆಸಿಫಿಕ್ ಫ್ಯಾಕ್ಟ್ 15 ನಲ್ಲಿ ಏನ್ ಹೇಳುತ್ತೆ, ಏನು ಯಾರು ಪಾರ್ಟಿ ಇದ್ದಾರೋ ನಮ್ಮ ಕಾಂಟ್ರಾಕ್ಟ್, ಪಾರ್ಟಿ ಟು ದಿ ಕಾಂಟ್ರಾಕ್ಟ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಅಪ್ರೋಚ್ ದಿ ಕೋರ್ಟ್ ಆಫ್ ಲಾ. So he can go and file an appeal, or the I'm sorry, say plaint, or the suit. Party to the contract will have to go to the court of law, who has entered into a contract. If the seller is agreed, he will have to go. If the purchaser is say agreed, he will have to go to the court. That means any person who is party to the contract can see he is eligible and is competent to the to see lay a suit, plaint before the court of law. So then we see, so we have come to the court now. All right, we has come to the court, document has come, person agreed has come to the court. So what is to be proved before the court? What we have to say, this is very, very important, for particularly for the say practicing lawyers, you know. See, ನಮ್ಮ ಗುರುಗಳು ಹೇಳ್ತಾ ಇದ್ರು ಹನುಮಂತಪ್ಪನವರು, ನಾವು ವಕೀಲರಾಗಿರ್ತಕ್ಕಂಥವ್ರು ಯಾವ ರೀತಿ ನಾವು ನೋಡ್ಕೋಬೇಕು ಕಕ್ಷಿದಾರನ ಅಂತ ಹೇಳಿದ್ರೆ ಕೇಳೋರು. ನೋಡಿ, ಕೋರ್ಟಿಗೆ ಬಂದವರು ಇಬ್ರು ಯಾರನ್ನು ಏನು ಇಬ್ರು ಕೇಸನ್ನ ಗೆಲ್ಲಿಯೋದಿಕ್ ಆಗೋದಿಲ್ಲ, ಅಥವಾ ನಮ್ಮ ಪಾರ್ಟಿ ನಮ್ಮ ಯಾವತ್ತೂ ಗೆಲ್ಲಿಯೋದಿಕ್ ಆಗೋದಿಲ್ಲ. ಗೆಲಿತಾನೆ, ಯಾವ ಎಲ್ಲಾ ಪಾರ್ಟಿನೂ ಗೆಲ್ಲಿತಾರೆ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಅವರಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ದಾಖಲೆಗಳು, ಕಾನೂನು, ಆಗಿನ ಕಾನೂನು, ಅದ್ರ ಮೇಲೆ ಆಗ ಬಂದಿರತಕ್ಕಂಥ ತೀರ್ಪುಗಳ ಮೇಲೆ ಅವಲಂಬಿಸಿರುತ್ತೆ. ಆದರೆ ಏನು ವಕೀಲರಾಗಿ ನಾವು ಮಾಡ್ತಕ್ಕಂಥ ಕರ್ತವ್ಯ ಏನಿದೆಯಲ್ಲ, ಆ ಕರ್ತವ್ಯ ಸರಿಯಾಗಿ ಮಾಡ್ಬೇಕು. ಏನು ನಮ್ಮ ಕರ್ತವ್ಯದಲ್ಲಿ ಲೋಪದಿಂದ ನಮ್ಮ ಕಕ್ಷಿದಾರನಿಗೆ ತೊಂದರೆ ಆಗಬಾರ್ದು. ನಮ್ಮ ತಪ್ಪಿನಿಂದ ಕಕ್ಷಿದಾರನಿಗೆ ತೊಂದರೆ ಆಗ್ತದೆ. ಅದು ಮೊದಲನೇ ಕರ್ತವ್ಯ ವಕೀಲರಿಗೆ. ಕಕ್ಷಿದಾರರಿಗೆ ಮಾರ್ಗದರ್ಶನ ನೀಡ್ತಕ್ಕಂಥವ್ರಿಗೆ ಅದು ಹೇಗೆ ಅಂತ ಇಲ್ಲಿ ಹೇಳ್ತೀನಿ ನೋಡಿ. ಸೆಕ್ಷನ್ 16 ಕೋರ್ಟಿಗೆ ಬಂದಿದ್ದೀವಿ ಈಗ. ಅಗ್ರೀಡ್ ಪಾರ್ಟಿ ಕ್ಯಾನ್ ಕಮ್ ಟು ದಿ ಕೋರ್ಟ್ ಅಂಡ್ ಪಾರ್ಟಿ ಟು ದಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಕ್ಯಾನ್ ಕಮ್ ಟು ದಿ ಕೋರ್ಟ್. ಓಕೆ, ವಿ ಆರ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ನಾವು. ಹೇಗೆ ಇಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕು ನೋಡಿ. ಸೆಕ್ಷನ್ 16 ನಲ್ಲಿ ಹೇಳುತ್ತೆ, ಪರ್ಸನಲ್ ಬಾಸ್ ಟು ರಿಲೀಫ್ ಕೊಡಕ್ ಸಾಧ್ಯನಿಲ್ಲ. ಅದಕ್ಕೆ ನಾವು ವಕೀಲರಾದವ್ರು ಕಾರಣರಾಗೋದು ಬೇಡ. ಯಾವಾಗ ಹೇಳ್ತಿದ್ವಿ, ಯಾವ ರಿಲೀಫ್ ಕೊಡೋದಿಲ್ಲ ಅಂದ್ರೆ, ಯಾವ ವ್ಯಕ್ತಿಗೆ ಕೋರ್ಟಿಗೆ ಬರ್ತಾನೋ ಅವನಿಗೆ ಕಂಪನ್ಸೇಷನ್ ಕೊಡೋದಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ಯಾರಿಗೆ ಕಂಪನ್ಸೇಷನ್ ಕೊಡ್ತಾರೆ? ಯಾರು ಕಾನೂನು ಪ್ರಕಾರ ಮಾಲೀಕನಾಗಿರ್ತಾನೋ, ಅಥವಾ ಯಾರಿಗೆ ಕಾನೂನು ಪ್ರಕಾರ ಅವನಿಗೆ ಜಮೀನು ಬರ್ಬೇಕು, ಹಣ ಬರ್ಬೇಕು, ಸೊ ಅಂತನಿಗೆ ರಿಲೀಫ್ ಕೊಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ, ಇಲ್ದಿರೆ ಇಲ್ಲ. ದೇರ್ ಇಸ್ ಎ ಬಾರ್ ಅಂದ್ರೆ ದಟ್ ಮೀನ್ಸ್ ಅವನಿಗೆ ಎಂಟೈಟಲ್ಮೆಂಟ್ ಇರಬೇಕು, ಇಲ್ದ್ರೆ ಕೊಡಕ್ಕಾಗೋದಿಲ್ಲ. ಆಮೇಲೆ ಯಾರು ತಾನೇ Irbodu, you may be a party to the agreement. You have come to the court, okay. Till then it is okay. But you have not performed your part of contract. ನಾನು 5 ಲಕ್ಷಕ್ಕೆ ನಾನು ಜಮೀನು ತಗೊಳ್ತೀನಿ, ಈಗ 1 ಲಕ್ಷ ಕೊಡ್ತೀನಿ, ಇನ್ನ 3 ತಿಂಗಳಲ್ಲಿ ನಾವು ಬಾಕಿ ಹಣವನ್ನು ಕೊಡ್ತೀನಿ, ನನಗೆ ನೀವು ಕ್ರಯಪತ್ರ ಮಾಡ್ಕೊಡ್ಬೇಕಂತ ನೀವು ಹಣ ಪರ್ಚೇಸ್ ಮಾಡೋರು ಹೇಳಿದ್ದೀರಿ. ಅವರು ಪೂರ್ತಿ ಹಣ ಕೊಟ್ಟ ಮೇಲೆ ನಾನು ನಿಮಗೆ ಸೇಲ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದಿರಿ. ಬಟ್ ನೀವು 1 ಲಕ್ಷ ಪ್ರಾರಂಭದಲ್ಲೇ ಕೊಟ್ಟವರು ಇನ್ನೊಂದು 4 ಲಕ್ಷ ಕೊಡದೇನೆ ಯು ಗೋ ಟು ದಿ ಕೋರ್ಟ್ ಆಫ್ ಲಾ. ನಂದು ಅಗ್ರಿಮೆಂಟ್ ಇದೆ, ನಾನು 1 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದೀನಿ, ಬಾಕಿ ಹಣ ಕೊಡದೇ ಇದ್ರೆ ನೀವು ಹೇಗೆ ನಿಮಗೆ ರಿಲೀಫ್ ಕೊಡುತ್ತೆ? ರೈಟ್, ಅಗ್ರಿಮೆಂಟ್ ಇದೆ, 1 ಲಕ್ಷನೂ ಕೊಟ್ಟಿದ್ದೀರಿ, ಅವನಿಗೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಡು ಅಂತಾನೆ ಹೇಳಿದಿರಿ, ಬಟ್ ಬಾಕಿ ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ. ಆರ್ ಯು ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ದಿ ರಿಲೀಫ್? ನೋ, ದೇರ್ ಇಸ್ ಎ ಬಾರ್ ಹೂ ಇಸ್ ಇನ್ಕೇಪಬಲ್ ಆಫ್ ಪರ್ಫಾರ್ಮಿಂಗ್ ಈಸ್ ಪಾರ್ಟ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್, who is incapable of completing his obligation. For those people also, the relief is barred under this section 16. Section 16 says the circumstances under which the person who has come to the court is not entitled for the relief are against whom the bar is there. And then another aspect I'm telling. Now I already said, one is who has not performed his part of contract, who is incapable performing his contract, and then who is not entitled for the compensation. And the another aspect is here, very aspect is that I said there should not be a fault on the part of the advocate. That is in respect of, that is 16C, very important. If we don't perform, then blame will be on the advocate. That is ready and willingness. Party responsibility improve ಇದೆ. So party must be ready, always ready and willing to perform his part of contract. That is the conditional precedent for the purpose of getting the relief in his favor. Party must be ready. Seller is not ready, then the purchaser will have to go to the court. But while going to the court, in the plaint, you must make a specific pleadings saying that the plaintiff was or purchaser was always ready and willing to perform his part of contract or pay the money, whatever it is. If the seller goes to the court of law, ಅವ್ರು ಹೇಳ್ಬೇಕು, ನಾನು ಯಾವಾಗ್ಲೂ ರೆಡಿ ಇದ್ದೆ ಅವನಿಗೆ ಮಾರಾಟ ಮಾಡೋದಕ್ಕೆ, ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ ಅವನೇ ಬಂದು ನನಗೆ ಬಾಕಿ ಹಣ ಕೊಡ್ಲಿಲ್ಲ, ಏನು ಇಲ್ಲ, ನನ್ನ ಕಡೆಯಿಂದ ಯಾವ ತಪ್ಪು ಇಲ್ಲ. I was always ready and willing to perform my part of contract, but my opposite party has failed to do so. Kindly give me the relief. So ಇದನ್ನ ಪಾರ್ಟಿನೂ ರೆಡಿ ಇರಬೇಕು, ಅದನ್ನ ನಾವು ಹೇಳ್ಬೇಕು. ದಟ್ ಈಸ್ ವಾಟ್ ಈಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಯಾರು ಹೇಳ್ಬೇಕು? ಅನ್ಲೆಸ್ ದ ಸೂಟ್ ಈಸ್ ಫೈಲ್ಡ್ ಬೈ ಎ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್, ಅಡ್ವೊಕೇಟ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಸೇ ಇನ್ ದಿ ಪ್ಲೇಡಿಂಗ್. ಅದೆಲ್ಲ ಬಂತು, ಡಿಫರೆನ್ಸ್ ಎಲ್ಲ, ಡಿಸಿಷನ್ಸ್ ಎಲ್ಲ ಬಂದಿದೆ ಇವಾಗ. ಏನಂತ ಹೇಳಿದ್ರೆ, ಸೊ ಅದೇ ಇದೆ ಮ್ಯಾಥಮೆಟಿಕಲ್ ಅಪ್ರೋಚ್ ಏನ್ ಬೇಕಾಗೋದಿಲ್ಲ, ಅದೇ ವರ್ಡ್ಸೇ ಬಳಸಬೇಕಾಗಿಲ್ಲ, ಓವರ್ ಆಲ್ ಪ್ಲೇಟ್ ನೋಡ್ಬೇಕು ಅಂತ ಹೇಳುತ್ತೆ. ಬಟ್ ಆ ಮೀನಿಂಗ್ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಅಲ್ಟಿಮೇಟ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳ್ತಕ್ಕಂಥದ್ದು. ಸೊ ಲೇಟೆಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಹೇಳುತ್ತೆ, ಇಲ್ಲ ಅದಾಗೋದಿಲ್ಲ, ಯು ಮಸ್ಟ್ ಸೇ ದಟ್ ಯು ಆರ್ ಆಲ್ವೇಸ್, ಐ ವಿಲ್ ಗಿವ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಆಲ್ಸೋ. ನಮ್ಮ ILR ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್, ಪ್ಯಾರೇಜಾನ್ ಕೇಸ್. ಐ ವಿಲ್ ಗಿವ್ ದಿ ಸೈಟೇಷನ್ ಆಲ್ಸೋ ಲೇಟರ್. So section wise, I will give the citations. See here, you must specifically say, ದಯವಿಟ್ಟು ಸರಿಯಾಗಿ ನಾವು ಇದನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳೋ ಪ್ರಯತ್ನ ಮಾಡೋಣ. ಇದರಲ್ಲಿ ಬಹಳ ಕೇಸಸ್ ಎಲ್ಲ ನಾವು ಕಳ್ಕೊಳ್ತಾ ಇದ್ದೀವಿ, ತೊಂದರೆ ಆಗಿದೆ, ನೋಡಿದೀವಿ ನಮ್ಮ ಅನುಭವದಲ್ಲಿ. ಅದನ್ನು ಹೇಳದೇ ಇದ್ದ ಮಾತ್ರಕ್ಕೆ ಸೂಟ್ ವಜಾ ಆಗೋಗ್ಬಿಡುತ್ತೆ. So section 16C is very, 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 very important so far as the parties and their advocates are concerned. Parties ready ಇರಬೇಕು, ಕ್ಲೈಂಟ್ ಅಲ್ಲೂ ನಾವು ಅದನ್ನು ಬರಿಬೇಕು. ರೈಟಿಂಗ್ ನಲ್ಲಿ ಬರಿದೇ ಇದ್ರೆ ಬರೀ ನೀವಲ್ಲಿ ನಾವು ಓರಲ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ನಾಳೆ ಇನ್ನೇನೋ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಾಗ ಇಟ್ ಈಸ್ ನಾಟ್ ಅಡ್ಮಿಸಿಬಲ್ ಅಟ್ ಆಲ್. ಆ ತಪ್ಪಿನಿಂದ ಪಾರ್ಟಿಗೆ ಅನಾನುಕೂಲ ಆಗಬಾರ್ದು. ಇಲ್ಲಿ ಡ್ರಾಫ್ಟ್ಸ್ ಮ್ಯಾನ್ ಡ್ಯೂಟಿ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಎಷ್ಟಿದೆ ಅಂತಕ್ಕಂಥದ್ದು ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಂಡು, ಅದೇ ರೀತಿಯಲ್ಲಿ if you don't say that ready and willingness expressly and explicitly in the plaint, you will not get the relief. So you must be very careful. ಅದೇ ರೀತಿಯಲ್ಲಿ ಕೂಡ specific relief act ಕೆಳಗಡೆ competent court can also give not only the land or immovable property which is the subject matter of the agreement or the contract. Even court may go to the extent of granting the compensation also in addition to the main relief. That also you must specify in your plaint. You are entitled for that. That is under section 21. You must plead for that. But so far, difference is this. Under section 16C, please kindly note the difference between section 16C and section 21, where you are claiming compensation as well. So there under section 21, we should not be confused or mistaken here. Under section 16, it is mandatory that you must, while filing the plaint, you have to say ready and willingness, always ready. Section 21 is concerned, though you are entitled for the both the relief, that is the property as well as the compensation, then even if you don't mention about the compensation, you can do it later also by way of amendment. It is permissible there. So you must know the distinction between the two to do justice to our party or to make the court to lay down a correct law. So this is how, while getting the reliefs also, we have to be very careful. So this is how section 16 provides very, very, very important aspect is section 16C, where it says you shall mention the readiness and willingness of your part of contract while laying your plaint before the court of law. And then I have also mentioned that if they don't defective title, if you acquire subsequently, you will the aggrieved party will get it also. And then enforceability, if there is any condition or subsequently after the agreement, if there is any changes or variations in the agreement, according to those variations also you are entitled for the relief. That is what section 18 says. And another section as section 16, another section is very, very important aspect is that section 19. Section 19 under the Act, parties and persons claiming under them by subsequent title. We have come across several cases. That is the rights of subsequent purchaser. 19B. Section 19B. Here, third party has entered into the scene. Till now, we have discussed saying that either the seller or the purchaser, parties to the agreement, so will get the relief. But under section 19, this is an exception to the general law under the Special Relief Act. We say that parties to the agreement. Here, third party has entered into, there is every possibility of the property going to the third party, that is the subsequent purchaser, who is not a party to the agreement at all. He will come to the picture, see later, as a subsequent purchaser, what are his rights? So under those circumstances, how to lay down the, say, a law, say, based on the pleadings. Pleadings are very, very, very important. Section 19B, according to me, it is an exception to the general law that we discussed till now under the enactment. So here, the subsequent purchaser will also get the benefit. Suppose you are appearing for the subsequent purchaser in a suit. To understand this, say, section 19, particularly 19B, see, he will come to you as a subsequent purchaser. He doesn't know while entering into the the original agreement with his party or purchasing, he does not know the existence of the earlier contract. He will come to you. What you normally will have to do to safeguard his interest. So under those circumstances, what we do is this. What we have to do, I think, normally to protect his rights. ನೋಡಪ್ಪ, ಇಲ್ಲಿ ಹೇಳಲಿಕ್ಕಾಗೋದಿಲ್ಲ, ಹಿಂದೆ ಎಷ್ಟು ಅಗ್ರಿಮೆಂಟ್ ಇರುತ್ತೋ, ಯಾರೇ ಸೇಲ್ ಮಾಡಿರ್ತಾರೋ, ಏನ್ ಮಾಡಿರ್ತಾರೋ ಗೊತ್ತಿಲ್ಲ. ನೀನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ಗಳೆಲ್ಲ ಸರಿಯಾಗಿ ವೆರಿಫೈ ಮಾಡು. 30 ವರ್ಷದ ಎನ್ಕಂಬರೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ತಗೊಂಬಾ, ಖಾತೆ ತಗೊಂಬಾ, ಟ್ಯಾಕ್ಸ್ ಪೇಯ್ಡ್ ರಿಸಿಟ್ ತಗೊಂಬಾ, ಪಾಣಿ ತಗೊಂಬಾ. ಇಷ್ಟಿದ್ರೂ ಸಾಕಾಗೋದಿಲ್ಲಪ್ಪ ನಿಮ್ಗೆ, ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ? ನಾವು ಹೇಳ್ತೀವಿ ಅವ್ರಿಗೆ, ಏನ್ ಹೇಳ್ತೀವಿ, ಇಷ್ಟಿದ್ರೂ ಸಾಕಾಗಲ್ಲಪ್ಪ, ದಯವಿಟ್ಟು ಏನೋ ನೀನು ಒಂದು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ಗೆ ಹೋಗು. Safeguard is that I am purchasing this property from so and so. If there is any objections from any person in respect to the scheduled property, please say whether you are interested in it or not. You tell your objections, if at all, if there is any objection at all. Otherwise, I will proceed with the sale. I am entering into contract with so and so. If you don't raise your voice within 15 days, 1 month, or whatever that is provided there under the notice, so I will proceed with it. No objections came. Then our party purchased it. He does not know anything at all. Then continued with the contract. He paid the amount. He did everything. So under those circumstances, though there is an agreement earlier to this, it is also valid. But he was not. This man was not knowing it. His seller said, "Yes, I am selling," without disclosing the earlier. So under those circumstances, if the subsequent, so-called subsequent purchaser was not aware of the earlier proceedings, earlier agreements, earlier understanding between the parties, though your seller has committed the mistake or fraud, misrepresentation, or whatever it is, but you are having the protection under section 19B of the Special Relief Act. That is the beauty of this enactment. Only thing is, you will have to establish that you are not knowing the earlier sale transactions. Maybe sale did, maybe say agreement to sale, whatever it is. I was not aware. I made all inquiries, but I was not knowing this. You must prove it. You must prove it. If you prove it, despite the earlier agreements, contracts, you will succeed. as a subsequent. That is the protection under section 19B. Very, very, very important. So this is how our reliefs are provided. Under section 19, but the particularly 19B, I said. This is an exception. We must know. Otherwise, in the normal course, the aggrieved party will have to go to the court of law. If he has got a case in his favor, he will win. Otherwise the defendant will win. But here is a case, but that must be. Subsequent purchaser will go and file an impleading application saying that I am so and so. Subsequently, if he comes to know that, then also pleading is very, very important. He must specifically mention that what are all the efforts made by him to ascertain the title of the property, despite that he was not knowing it. So therefore he purchased it. If he does not say in his pleading specifically and prove it subsequently, he will not get the benefit. But law provides for him the benefit, but he will have to prove it. What is his duty? So these are the conditions we have to tell, plead, and argue before the court. So these are the protections provided to the subsequent purchaser, which is an exception to the earlier provisions of law under the enactment. Very interesting. If he does not say so, mere telling in the open court or mere telling in the witness box orally is of no use at all. So these are the circumstances. And then coming to section 20. So section 20 that has been subjected to so many amendments. Earlier it was dealing with the discretion. Now through third party also we can get the relief. But ultimately what is important is discretion. These are the discretionary reliefs. So I said equitable and discretionary reliefs. So, but what kind of relief? This is very, very important. We see court, of course, court has got the discretionary reliefs. Discretion has got. But what kind of relief? What kind of discretion court has to exercise? As we know, it must be judicious discretion. It's all right, judicious. But while granting judicial discretion, you must assess, weigh, in whose favor justice lies. So arbitrary way, that will not suffice the law under section 20 or under the specific fact. So discretion must be exercised judiciously. Court will have to examine, is it sufficient if I direct the defendant to pay the amount received to the plaintiff, maybe with interest, maybe with compensation. Will it be, question is, while exercising the discretion, so you must also examine, in addition to that, directing the defendant to pay the compensation, will it be one of adequate relief for the plaintiff? Prerequisite. If court is not satisfied, that it is not adequate, then court will have to say that he is entitled for the property. So that is the matter to be examined by the court, so before which the suit is filed. Otherwise, by paying the amount also. Sorry for the interruption. So that is how court will have to examine. So discretion. So discretionary relief has to be in the manner known to law means, so that discretion must be exercised judiciously. That is, I will also come to that, the provisions of granting injunctions also. So here, all that I say this, so when come to the court of law, so then we have filed the case, third party, and we have come to the say level of getting the relief under section 20. So that relief, while granting the relief, so a party's position must be exercised with the say judicious discretions. Then I already mentioned the section 21. So 21 I mentioned, in addition to the main relief of getting the property, you may be entitled for compensation and must make a mention also in the plaint. Now, if you don't make a mention, then there is some margin saying that you can seek for amendment also subsequently. Court provides for that. But ultimately, it should be part of the pleadings. That is again the specific duty of an advocate while presenting the plaintiff, the matter is being filed say through the advocate. That is our responsibility. Unless you make a say claim in the plaint or the pleading, you are not entitled for that relief. Though you are entitled for law, entitled in the eye of law. So advocate must be very, very careful here. So for fault of advocate, party should not suffer. So that is what section 21 says. So pleading is very, very important. Unless it is specifically mentioned, you will not get the relief. That is the law, that is the decision on the point. So that we must bear in our mind. So, and then another aspect is say, if there is a say, even if there is a say default provision, one more important under the agreement. So if you don't pay within this amount, say I am going to say cancel the say agreement. Maybe sometimes normally seller will say, even in the absence of even if there is a default clause under the agreement, then also you can go to the court of law saying that though there is a default clause under the agreement, but I am entitled for this specifically. That is also permission in the eye of law. So that is what section 24 says. And then so settlements similar way under section 25. Now another thing, chapter 3, that is deals with the rectification of instruments. See, this is also specific relief. Rectification of instruments, in case of rectification, there is some mistake in the instrument. Mentioning of the boundaries, extent. Sometimes, we mention, 2 acres, so instead of mentioning 3 acres. But in the boundaries, schedule we mention at the end of the instrument or document. In the schedule, we give, boundaries for 3 acres, but in the body of the document, we mention only 2 acres or 2 acres, 2.5 acres. So later we come to know. Then you can seek for rectification, saying that ultimately we agreed for 3 acres. So many such things will be there. So if there is a lapse in mentioning, you can. But so far, one thing as I know, so if boundaries are correct, ultimately boundaries prevail over the extent. Though you are mentioned in the body of the plaint saying that 2 acres 5 guntas, if boundary covers 3 acres, you are entitled for 3 acres only. That is the law. If I am right, saying that if boundaries prevails over the extent. But even then, some people seek for rectification. Similarly, so many things rectification. If you come across, the defects or the mistakes, which are required to be corrected under the instrument, definitely you can go to the court of law. That must be according to law only. If you say that subsequent to the document, these are the developments, this requires rectification. Whatever rectification in the area of law you are entitled for, subsequent to the instruments, definitely, if other side doesn't agree without going to the court of law, definitely you can go to the court of law and get it rectified by obtaining the decree to the law. That is what, chapter 3 provides for that rectification of instruments. And you must also prove that there was an instrument, it was in accordance with law, competent between the parties, and valid agreement or the contract. If you prove all those things, and you also show that, in the eye of law, you are entitled for the, rectification of documents, that is also provided. So then another aspect, rescission of contracts. Rescission is nothing but to see the cancellation of contracts, abandoning the contracts. See, after the contracts, you will come to know so many things. See, saying that it is not possible to perform the agreement. You may come to know subsequently saying that the seller has taken a lot of money, but this is not permissible to purchase the land. He had no title over the same. So under those circumstances also, court is competent to grant a decree under the specific defect for rescission of contracts, cancellation of the contracts. Provided you prove before the court if your innocence, say at the time of entering into contract and involved in the contract. So if it is according to law only, then you are entitled for it. But court is competent to grant the rescission of contract. So in the circumstances in which it has taken place, if you establish before the court, it is not permissible under law. And then similarly, say cancellation of instruments, almost an identical instrument. Next, say that is section 31. I'm sorry. Okay. The rescission of contracts. Similarly, say cancellation of instruments. That is section 31. Yes. So rectification of instruments, cancellation of contract, rescission of contracts, and then cancellation of instruments. Cancellation also can be done. If you prove before the court, say that requires to be cancelled in the IFL because it is not enforceable, or say nobody will get any benefit under the, it is again maybe sometimes against law. Under those circumstances also, so those documents can be cancelled. These are the remedies provided under the say specific effect. And then say very important is say another see declarationary decrees. So here also the lawyer's responsibility is very, very important. So under section 34, declaratory decrees, in the normal course, everybody is entitled for the declaratory decree. See, if he proves that he is entitled for the reliefs. But what is important is, while say filing the suit for declaration, if you are entitled for a mere declaration, suit for declaration is sufficient. But say, if you need more than the declaration of title, suppose you are not in possession of the property, you file only for declaration saying that you are the owner of the property. Are you entitled for the, say, relief sought for? If court comes to conclusion that the plaintiff is not, you see, not only entitled for the declaration, but he is also required to go for some other reliefs. But there are no prior for that. Are you entitled for the declaratory decree? No. Here also, if you are not in possession, in addition to title, you have to seek possession also. If it is already in possession of some other person, and if there is a threat, in addition to that, you have to seek injunction also. Ancillary reliefs or consequential reliefs. Under those circumstances, in the absence of those reliefs, prior for that, mere declaratory suit is not maintainable under section 34. Normally, say when we begin the profession, you know, say we do commit this type of mistakes. So we must be very careful. But this is also relief provided. That does section 34 means, that does not mean that you are not say entitled for other reliefs in other say provisions of law. Under general law, that is CPC. But Section 34 provides under what circumstances you can go for declaratory reliefs. And how you have to make a prayer, how you have to, what is that is required to be established, and how you see you have to frame your prayer in the plain. That means in a suit for declaration, your prayer must be exact and comprehensive, specific and comprehensive. In the absence of that, you are not entitled for, say, even if you obtain the decree, it is of no consequence, no use at all. So that we must bear in our mind, and say that is declaratory. And then I will come to the last part, that is preventive reliefs. That is special reliefs. These are all special reliefs. So special reliefs. So these are preventive reliefs under the specific. They are called as preventive reliefs. Because you prevent the person who is committing default, some illegal act, doing illegal. So they are called as injunctions. So injunctions, coming to injunctions, there are 3 types, injunction. Permanent injunction, that is perpetual injunction we call. Temporary and mandatory injunctions. So here you see very, very important thing is, while granting these reliefs, particularly preventive reliefs, lawyers, clients, and also courts must be very, very, very clear. Because suppose interim relief, interim injunction, ad interim injunction is also mostly, an urgency we go to the court of law. If your deserving party does not get the relief, definitely what would be the consequence? Not only the permanent injunction, which is also most important, the temporary injunction is also important. So for example, corporation, I don't say Bangalore Corporation only. Any corporation issue a notice to a person saying that, so you have built up, your house very, illegally, and you are not entitled for that. So we are going to demolish your house. You file a suit. Aggrieved person will file a suit. He will seek temporary injunction. So in 3 days, we are going to demolish. So here, if judicious discretion is not exercised by the competent court of law, what would be the consequence? If no temporary injunction is granted, tomorrow corporation people will go and demolish it. The consequence should be, party will say, my suit has become infructuous. And even if he continues the suit, tomorrow he succeeds. What would be the consequence? He has no house at all. You will be on the street till then. We know how much time it takes, for the final decision in a suit. So therefore, while granting temporary injunction, particularly our pleadings, and also court also must exercise the discretion, judicious exercise of judiciary. Otherwise, sometimes the party will also lose this. I suppose genuine, of course, that is there. All parties are not a Satya Harishchandra before the court. In fact, one of the great justices, I don't want to mention their name also, but was telling, so, sir, you are granting, my lord, you are granting very, interim reliefs very easily. And we lose when you retire and all those things. Then justice was telling, I was granting because, so the other side can come and file an application for vacating. Because if there is a wrong exercise of discretion, maybe knowingly or unknowingly. See, genuine party, if he put into possession, put into difficulty, tomorrow he will lose the confidence in the system at all. Finally, he will lose. He will not come to the court at all. Even if the interim relief is granted, other side will come and file an application. Time is also fixed under the law, and it is always open for the other side. So here, what is to be examined is whether the suit is filed against the authority or private person. Consequences of granting or not granting these discretion reliefs are very, very important. So temporary injunction or temporary relief will be granted. At the initial stage, we make an application along with the main claim, the application for interim order. Therefore, they are called as temporary injunctions. And normally, that is in between filing of the suit and disposal of the suit. So we file this type of the applications. That is what is called temporary injunction. And then we also know the permanent injunction. That is the end of the suit. At the end of the suit, so depending upon the evidence available on the record, pleadings available on the records, the court will come to conclusion that whether that party is entitled for the permanent relief or not. If he has got a good case, then he will get the relief. Otherwise, he will get his suit dismissed. And then mandatory injunction. So mandatory injunction, we know that that is also granted by the court. Directing the party who has done mistake or wrongfully constructed, done a act which is not permissible in law, he will be directed to correct it. That is mandate. Mandatory means direction by the competent court, directing certain party who is at fault to correct the mistake committed by him within certain time. That is what is called mandatory, injunction, direction. So all these three types of orders will be granted. That is, they are called as preventive reliefs under the Act because, virtually, if you grant an injunction order, he will be prevented from doing certain acts. Therefore, they are called as, preventive reliefs. Other words, so by way of injunctions, by way of restraining the person other side from doing certain things for a particular period, or maybe permanently, finally. So these reliefs, particularly provided under, very urgent circumstances, injunctions. While granting, considering this also, so parties must be very, very, careful, while placing their cases before the court, supporting documents and the convincing reasons for the purpose of granting these reliefs. Merely filing a suit, merely praying, making a prayer before the court is not sufficient. And very, very important responsibility, is put on the courts also, because it is also for, after all, so they are also human beings, justice also. They will do it, they will do their duty, but that discretion reliefs are to be, there is discretion. What I am saying is, so those discretions must be, judicious discretions, then only, because ultimately, again, I am quoting some saying that, while party going back to his house, even after losing his case, he should not feel that, so I lost my case, not because of my the lack of merit in my case, but because of so and so, maybe lawyer, maybe court, maybe the system. That should not be the blame. Ultimately, system is important in a democracy. Therefore, these are the reliefs provided under the main reliefs. I am citing almost all these sections I am trying to cover. Under what circumstances we are entitled for, under what circumstances this act came into force. What are the circumstances under which we are entitled for these 7 reliefs I said. Reliefs provided under the enactment, covering 40 sections. So these are the circumstances under which you are entitled for the reliefs. So very, very interesting. So therefore, all that is required under the enactment is what we have agreed to do. You do as agreed is the principle on which these provisions are based. Thank you very much. Thank you very much. Before that, I will give you the decisions in 1 or 2 minutes. That's all. See, I was telling this enactment is not exhaustive, and wherever the decision is not available to decide the conflict, we can also decide rely upon the law of the England also even today. That is a judgment AR 1951 Mysore, page 59. Ramatullah versus Srimoga, SRIMOGGA. My appeal to my young friends, if there are any, is whenever you take a citation, kindly take the name of the parties. That will be very, very useful for you. Here 1990, I am repeating, 1951 Mysore, page 59. Ramatunnisa versus Srimoga. So this is confirmed by the Supreme Court in the AR 1972 Supreme Court. AR 1972 Supreme Court 1826. Hindustan Investment Trust versus Haridas Munro. And then section 6, I was mentioning that appeal is not provided, only revision is provided. So revision is provided as per decision of our Karnataka High Court. That is AR 1994 Karnataka, page 350. 350. AR 1994 Karnataka 350. Revision is maintainable and not appeal. Mehboob Pasha versus Vishwanath Chetty. Mehboob Pasha versus Vishwanath Chetty. This is also from Karnataka. And then say one more is time is the essence of the contract or not is also there is a decision 1977 Supreme Court 1005. Time is not the essence of the contract unless that contract provides for the same. That is Govind Prasad versus Harry Dutt. And then coming to section 16, that is subsequent purchaser. Year 2005, 2000 Supreme Court, year 2000 Supreme Court, 2408. And one more judgment, 2408 judgment, party name, Motilal Jain versus Ramadasi Devi. And there one more judgment, ILR 2006 Karnataka 1207 within bracket SC Supreme Court judgment, ILR bandire Supreme Court judgment under section 16, that is Parijan judgment, Parijan versus Dasappa. Then 2006 part 2 SCC (496). Same judgment. That is a report, Parijan there, sorry. And then say under section 19B one more. 2001 AR 2000 SC 1658. 19B nalli subsequent purchase.
AR 2001 SC, please sir.
Sir, AR 2001 SC 1658. Muhammad Ubaidullah versus Haji. And then 2008 AIR SCW 6645. Yes, Abdul Qadar versus Abdul Wazid These two judgments are under section 19B, that is subsequent purchaser rights and responsibilities. And then AR 2000 SC 3106 Gobindra versus Gyan Chand, that is section 20. How discretion is to be exercised while granting release under this enactment. Discretion must be fair, just and equitable. And then on the point of say equity, what is the meaning of equity? 2006 AIR SCW 6320. MP Mathur versus DTC. So this is what it says. He who comes to equity must do equity. So finally, I will conclude by saying that, see, Lord Denning said, see, a deserted wife had come to the court to protect her, say, possession of a house from her deserted husband. He filed a suit, husband filed a suit. Lord Denning said, deserted wife is entitled for possession till she gets the alternative remedy of getting an accommodation. Question was before the court, on what basis she is entitled? Because deserted wife is not the owner of the property. That was the contention of the husband. I have got title. I am the owner in law, according to law, under the law. How is she entitled to continue? Indisputably, she is a deserted wife. Justice said, Denning said, she is entitled for possession to continue. She can't be on the street because she was your wife. On the principle of equity, she is entitled to continue in possession till she get the alternative accommodation. So that is the judgment I will give you. 1952, 2 Queen's Bench 466. If you are having already Lord Denning's books, you can see due process of law, page 210. Under the heading wife's equity. There the principle of equity is well explained. Friends, thank you very much. Thank you very much. You have given a patience hearing to me. So with this, I conclude. Once again, I am grateful to Bar Council of India, Karnataka, and also Law Academy for having given this opportunity. Thank you. Thank you one and all.
Sir, thank you so much. ಆತ್ಮೀಯ ಬಂಧುಗಳೇ, ಕಳೆದ 2 ಗಂಟೆಗಳಿಂದ ನಿರಂತರವಾಗಿ ಸ್ಪೆಸಿಫಿಕ್ ರಿಲೀಫ್ ಆಕ್ಟ್ ಸಂಬಂಧಪಟ್ಟಂತೆ ಜೊತೆಗೇನೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಮತ್ತೆ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ನ ಹಲವಾರು ವಿಷಯಗಳನ್ನ ಇವತ್ತಿನ ನಮ್ಮ ಈ ವೇದಿಕೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ KSBC ಲಾ ಅಕಾಡೆಮಿಯ ಈ ಒಂದು ಅಂತರ್ಜಾಲ ಕಾನೂನು ತರಬೇತಿ ಕಾರ್ಯಾಗಾರ, ವಿಶೇಷವಾಗಿ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಧೀಶರ ಹುದ್ದೆಗೆ ಯಾರೆಲ್ಲ ಮುಖ್ಯ ಪರೀಕ್ಷೆಯನ್ನು ತೆಗೆದುಕೊಂಡಿದ್ರೋ ನಮ್ಮೆಲ್ಲರಿಗಾಗಿ ಕರ್ನಾಟಕ KSBC ಲಾ ಅಕಾಡೆಮಿಯವರು ಈ ಒಂದು ಉಪನ್ಯಾಸ ವೇದಿಕೆಯನ್ನ ಪ್ರಾರಂಭ ಮಾಡಿ ಇಂತಹ ಒಂದು ಉಪನ್ಯಾಸ ವೇದಿಕೆಯಲ್ಲಿ ಗೌರವಾನ್ವಿತರನ್ನ ಕರೆಸಿ ತಮ್ಮೆಲ್ಲರಿಗೂ ಉಪನ್ಯಾಸವನ್ನು ನಡೆಸಲಿಕ್ಕೆ ಏನು ಪ್ರಯತ್ನ ಮಾಡ್ತಿದ್ದಾರೆ. ಇಂಥ ಒಂದು ಪ್ರಯತ್ನದಲ್ಲಿ ಭಾಗವಾಗಿ ಇವತ್ತು H. ಕಾಂತರಾಜ್ ಸರ್ ಇವತ್ತು ನಮಗೆ ಸಾಕಷ್ಟು ವಿಷಯಗಳನ್ನ ತಿಳಿಸಿಕೊಟ್ಟಿದ್ದಾರೆ. ಗೌರವಾನ್ವಿತರ ಇವತ್ತಿನ ವಿಷಯಕ್ಕೆ ಸೀಮಿತವಾಗಿ ಯಾರಿಗೆಲ್ಲ ಪ್ರಶ್ನೆಗಳಿದಾವೆ, ಸಂದೇಹಗಳಿದಾವೆ, ಆ ಒಂದು ಪ್ರಶ್ನೆಗಳನ್ನ ತಾವು ಕೇಳಬಹುದು. ಯಾರಿಗೆಲ್ಲ ಕೇಳಿಕ್ಕೆ ದಯವಿಟ್ಟು ಹ್ಯಾಂಡ್ ಅನ್ನ ರೈಸ್ ಮಾಡಿ, ನಂತರದಲ್ಲಿ ನಿಮಗೆ ಅವಕಾಶವನ್ನ ಕೊಟ್ಟಾಗ ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು ಪರಿಚಯ ಮಾಡ್ಕೊಂಡು ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳಬೇಕು ಅನ್ನುವಂತ ವಿನಂತಿಯನ್ನ ಮಾಡ್ತಾ, ಮೊದಲಿಗೆ ನಾನು TDP ಅಡ್ವೊಕೇಟ್ ಅಂತ ಹೆಸರು ಹಾಕೊಂಡಿದ್ದೀರಿ. ನಿಮ್ಮ ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ರಿಕ್ವೆಸ್ಟ್ ಅನ್ನ ಮಾಡಿದ್ದೀನಿ. ದಯವಿಟ್ಟು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ಎಸ್ ಸರ್. ಸರ್ ಹಲೋ
ಹಲೋ ಹೇಳಿ.
ಸರ್ ಕೇಳಿಸ್ತಿದೆ ಸರ್?
ಕೇಳಿಸ್ತಾ ಇದೆ.
ಕೇಳಿಸ್ತಿದೆ ಹೇಳಿ.
ಸರ್ ನಮಸ್ತೆ, ನನ್ನ ಹೆಸರು ಪುರುಷೋತ್ತಮ್ ಅಂತ ಹೇಳಿ.
ಹೇಳಿ.
ಸರ್ ನಾನು ಹಿಂದೆ ಹಾಸನ್ ಬಾರಿಂದ. ಸರ್ ಇವಾಗ ಸ್ಪೆಸಿಫಿಕ್ ರಿಲೀಫ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಸೆಕ್ಷನ್ 22 ಸಬ್ಕ್ಲಾಸ್ 2 ಅಲ್ಲಿ ಏನು ಅವರು ವಾದಿ ಏನಿರ್ತಾರೆ, ಅವರು ದಾವಾದಲ್ಲಿ ವಾದ ಪತ್ರದಲ್ಲಿ ಪರಿಹಾರ ಕೇಳ್ದಾನೆ ಹೋದಾಗ ಅದನ್ನ ಗ್ರಾಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ಡಿಫೆಂಡೆಂಟ್ ಕಂಟೆನ್ಷನ್ ತಗೊಳ್ತಾರೆ ಸರ್.
ಹೌದು.
ಆ ವೇಳೆಯಲ್ಲಿ ಈಗ ಕೋರ್ಟ್ ಯಾವ ರೀತಿ ಇದನ್ನ ಡಿಸ್ಕ್ರಿಷನರಿನ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡುತ್ತೆ ಸರ್?
ಅಲ್ಲ, ಅದನ್ನ ಹೇಳಿದೆ ನಾನು. ಅಂತ ರಿಲೀಫ್ ಕೇಳದೆ ಇದ್ದಾಗ ಅಲ್ಲಿ ಆ ಪ್ರಾವಿಷನ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಯು ಕ್ಯಾನ್ ಸೀಕ್ ಅನ್ ಅಮೆಂಡ್ಮೆಂಟ್. ಸಿ, ಇದು ಅನ್ಲೈಕ್ ಸೆಕ್ಷನ್ 16 ನಲ್ಲಿ ರೆಡಿ ಅಂಡ್ ವಿಲ್ಲಿಂಗ್ನೆಸ್ ಅಂತ ನೀವು ಪ್ರೂವ್ ಮಾಡದೇ ಇದ್ರೆ ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಬಹುದು. ಬಟ್ ಇಲ್ಲಿ ಕೂಡ ನೀವು ಇಂಥ ರಿಲೀಫ್ ಕೊಡದೇ ಇದ್ದ ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ ಕ್ವಶನ್ ರೈಸ್ ಮಾಡಿದಾಗ ಡೆಫಿನೆಟ್ಲಿ ಯು ಕ್ಯಾನ್ ಫೈಲ್ an application for amendment seeking that particular relief. Then court will have to grant because section provides for that. Section 21 ಇಂದನೂ ಅದು ಪ್ರೊವೈಡ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. So kindly file an application. So that is permissible in law, provided you explain as to why you could not file this application earlier to this.
ಈಗ ಎಕ್ಸಾಮ್ ಅಲ್ಲಿ ಕೇಳಿದ್ದಾರೆ ಸರ್, ಅದೇ ಹಂಗಾಗಿ ಕೇಳಿದೆ. ನಾವೀಗ ಪ್ರಿಸಮ್ ಮಾಡ್ಕೋಬಹುದಾ? ಹಂಗೆ ಪ್ಲೈಂಟಿಫ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ,
ನೀವು ಹೇಳ್ಬೇಕಾಗತ್ತೆ. ಅಂಡರ್ ದೋಸ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್, if such a mistake has crept in your pleadings, so you will have to tell the answer saying that under those circumstances there is a provision for filing an application seeking the permission to file make an amendment in addition to the prior already made.
ಅವಾಗ ಸೆಕ್ಷನ್ 20 ಬರುತ್ತಾ ಸರ್? ಡಿಸ್ಕ್ರಿಷನರಿ ಪವರ್ ಆಫ್ ದಿ ಕೋರ್ಟ್.
ಹೌದೌದು, ಕೋರ್ಟ್ ಬರುತ್ತದೆ. ನಿಮ್ ಕ್ಲೈಮ್ ಇರ್ಬೇಕಲ್ಲಿ. ಕ್ಲೈಮ್ ಇರ್ಬೇಕು. ಅದು ಬರೀ ಓರಲ್ ಆಗಿ ಹೇಳಿದ್ರೆ ಕೇಳೋದಿಲ್ಲ.
ಇವಾಗ ಸರ್ ಇವಾಗ ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ ರಿಲೀಫ್ ಕೇಳಿರೋದೇ ಅಲ್ಲ ಸರ್. ಈಗ ರಿಫಂಡ್ ಆಫ್ ಅರ್ನೆಸ್ಟ್ ಮನಿ ರಿಲೀಫ್ ಕೇಳಿರೋದು.
ಅದನ್ನೇ ನೀವು ಕೇಳಿಲ್ಲ ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ಎ ಲ್ಯಾಪ್ಸ್. ಅದು ಈಗ ಕೇಳಬಹುದು, ಕೇಳೋದಕ್ಕೆ ಅದು ಪ್ರಾವಿಷನ್ ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಬೈ ಮೇಕಿಂಗ್ an amendment application.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
With proper explanation. Okay.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ರಂಗಪ್ಪ SD ಅವರು ದಯವಿಟ್ಟು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ. ನಿಮ್ಮ ಪರಿಚಯ ಮಾಡ್ಕೊಂಡು ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳಿ.
ಸರ್, ರಂಗಪ್ಪ ದೊಡ್ಡದೇವಣ್ಣವ್ರ ಅಂತ, ರಾಣೆಬೆನ್ನೂರು ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಸರ್.
ಪ್ಲೀಸ್.
ವೆರಿ ಗುಡ್ ಈವ್ನಿಂಗ್ ಸರ್.
ವೆರಿ ಗುಡ್ ಈವ್ನಿಂಗ್.
ಏನ್ ಸರ್? ಎಸ್ ಸರ್, ಒಂದು ಕ್ವೆಶ್ಚನ್ ಸರ್ ನನಗೆ. ಆಫ್ಟರ್ ಲ್ಯಾಪ್ಸ್ ಆಫ್ 6 months ಆಫ್ ದಿ ಡಿಸ್ಪೊಸಿಷನ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ,
section 6.
yes sir, we have the so much remedies are there, you have told to me, and as such you have also in speech, but after 6 months what remedy can I ask before this?
ನೋಡಿ, ಅದನ್ನ ಹೇಳೋದು. ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದೆ, ಬಿಗಿನಿಂಗ್ ನಲ್ಲಿ ಹೇಳಿದೀನಿ, this specific relief act is not an exhaustive one. 1972 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಫಸ್ಟ್ ಕೊಟ್ಬಿಟ್ಟಿದೀನಿ, ಅಲ್ಲಿ ಎಕ್ಸಾಸ್ಟಿವ್ ಅಲ್ಲ. ಸೊ ಏನಂದ್ರೆ ಈ ಸ್ಪೆಸಿಫಿಕ್ ರಿಲೀಫ್ ಆಕ್ಟ್ ಕಡೆ ನೀವು ಬೇರೆ ಕೇಳಕ್ ಬರೋದಿಲ್ಲ. ಜನರಲ್ ಆನಲ್ಲಿ ಅದರ್ ಸೂಟ್ಸ್ ಕ್ಯಾನ್ ಬಿ ಫೈಲ್ಡ್. ಎಸ್, ನಾನು ಅದನ್ನೇ ಹೇಳಿದೆ. ದಿಸ್ ಈಸ್ ನಾಟ್ ಎಕ್ಸಾಸ್ಟಿವ್. ಇಫ್ ಯು ಸೇ ಅಂಡರ್ ಸೆಕ್ಷನ್ 6, those conditions must be fulfilled. Otherwise you have to go under the general law, whether you get the relief or not. Suit is mentioned about.
Yes sir. Okay.
Thank you sir. ರೇವಣಗೌಡ ಅವರು ದಯವಿಟ್ಟು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನಿಮ್ಗೆ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಅವಕಾಶವನ್ನು ನೀಡಿದೆ. ಎಸ್, ಪರಿಚಯ ಮಾಡ್ಕೊಂಡು ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳಿ.
ಹಲೋ,
ಎಸ್
ಹೇಳಿ.
ರೇವಣಗೌಡ ಅವರು.
ಸರ್, ರೇವಣ್ಣ ಸರ್, ಬೆಂಗಳೂರು ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಇಂದ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ.
ವಾಯ್ಸ್ ಲೌಡ್ಲಿ ಬರ್ಲಿ ಸರ್.
ಇಲ್ಲ, ವಾಯ್ಸ್ ಕ್ಲಿಯರ್ ಇಲ್ಲ.
ಹಲೋ,
ಜೋರಾಗಿ ಮಾತನಾಡಬೇಕು, ಕೇಳಿಸ್ತಿಲ್ಲ, ಹೇಳಿ.
ಸರ್, ನನ್ನ ರೇವಣ್ಣ ಅಂತ ಸರ್, ಬೆಂಗಳೂರು ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಇಂದ.
ರೇವಣ್ಣ, ಮೆಸೇಜ್ ಕೇಳಿಸ್ತಾ ಇದೆ, ವಾಯ್ಸ್ ಕ್ಲಿಯರ್ ಆಗಿ ಬರ್ತಾ ಇಲ್ಲ.
ಹಲೋ,
ಕೇಳಿ.
ಹಲೋ,
ಕೇಳಿ.
ಸರ್, ನಂದು ಕ್ವಶನ್ ಬಂದು ಸೆಕ್ಷನ್ 19B ಸರ್.
ಹೇಳಿ.
ಹಲೋ,
ಹೇಳಿ ಸರ್. 19B ನಲ್ಲಿ ಏನ್ ಸಮಸ್ಯೆ, ಏನ್ ಪ್ರಶ್ನೆ ಇರೋದು ಕೇಳಿ.
19B ನಲ್ಲಿ ಈಗ ಅದ್ರ ಪ್ರಕಾರ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಪರ್ಚೇಸರ್ಗೆ ಅದು
ವಾಯ್ಸ್ ಬ್ರೇಕ್ ಆಗ್ತಾ ಇದೆ.
ಸರಿ ರೇವಣಗೌಡ ಅವರೇ, ನಿಮ್ಮ ಧ್ವನಿ ಸ್ಪಷ್ಟವಾಗಿ ಕೇಳ್ತಿಲ್ಲ. ಬಹುಶಃ ತಾಂತ್ರಿಕ ತೊಂದರೆ ಇದೆ ಅನ್ಕೊಂತೀನಿ. ನೆಕ್ಸ್ಟ್ ಮುನೇರಾ ಅವರು ದಯವಿಟ್ಟು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ನಮಗೆ ಫೋನ್ ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳಿ.
ಪ್ಲೀಸ್ ಸರ್. ಗೌರವಾನ್ವಿತರಿಗೆ ತಾವು ನಂತರದಲ್ಲಿ ಯಾರೋ ರೇವನ್ಗೌಡ ಅವರು ಇದ್ದೀರಿ, ನಿಮಗೆ ಏನು ಪ್ರಶ್ನೆ ಇದೆ, ಸಂದೇಹ ಇದೆ, ನೀವು ನಂತರದಲ್ಲಿ ಗೌರವಾನ್ವಿತರಿಗೆ ಫೋನ್ ಮಾಡಿ ನಿಮ್ಮ ಸಮಸ್ಯೆಯನ್ನ, ನಿಮ್ಮ ಪ್ರಶ್ನೆಯನ್ನ ಕ್ಲಿಯರ್ ಮಾಡ್ಕೋಬಹುದು. ಎಸ್ ಮುನೇರ ಅವರು ಸರ್, ಮನೆಯಲ್ಲಿ ಚರ್ಚೆ ಮಾಡ್ಲಿಕ್ಕದ್ರು, ಪ್ರಶ್ನೆ ಕೇಳಿಕತ್ರ
ಸರ್.
ಮನೆಯಲ್ಲಿ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಬಾಳ ಇದೆ ನೋಡ್ರಿ.
ಪ್ಲೀಸ್ ಸರ್. ಸರ್, ಅನ್ಡಿವೈಡೆಡ್ ಶೇರ್ ಎಲಿಮಿನೇಟ್ ಮಾಡೋ ಅಗ್ರಿಮೆಂಟ್ ಎನ್ಫೋರ್ಸೇಬಲ್.
ಸಾರಿ ಸರ್, ನನ್ಗೆ ಕ್ವಶನ್ ಗೊತ್ತಾಗಿಲ್ಲ.
ಅನ್ಡಿವೈಡೆಡ್ ಶೇರ್ ಅನ್ನ ಎಲಿಮಿನೇಟ್ ಮಾಡೋ ಅಗ್ರಿಮೆಂಟ್ ಎನ್ಫೋರ್ಸೇಬಲ್ ಸ್ಪೆಸಿಫಿಕ್ ರಿಲೀಫ್.
ಸಾರಿ, ನನಗೆ ಐ ಹ್ಯಾವ್ ನಾಟ್ ಬೀನ್ ಏಬಲ್ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಯುವರ್ ಕ್ವಶನ್. ಬ್ರೇಕ್ ಇದೆ ವಾಯ್ಸ್.
ಸರ್,
ನೆಕ್ಸ್ಟ್ ವಿಜಯ್ ಕುಮಾರ್ ಬಾಗೋಜಿ ಅವರು ದಯವಿಟ್ಟು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಸರ್, ಅದು ಕೇಳಿ ಸರ್. ಸರ್, ಇದು ಯಾರಿಗೆ ಕ್ಲಿಯರ್ ಇಲ್ವೋ ನನ್ನ ಫೋನ್ ನಂಬರ್ ಬೇಕಾದ್ರೆ ಕೊಡ್ಬೋದು.
ಕೊಡ್ತೀನಿ ಸರ್. ವಿಜಯ್ ಕುಮಾರ್ ಬಾಗೋಜಿ ಅವರು ದಯವಿಟ್ಟು ಧ್ವನಿಯನ್ನ ನೀವು ಎರಡು ಸಿಸ್ಟಮ್ ಅನ್ನ ಇಟ್ಕೊಂಡಿದ್ರೆ ಒಂದ್ ಸಿಸ್ಟಮ್ ಅನ್ನ ಆಫ್ ಮಾಡ್ಬಿಡಿ ಸರ್, ಇಲ್ಲ ಅಂತಂದ್ರೆ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಆಗ್ತದೆ. ಓಕೆ ಕೇಳಿ.
ಒಂದು ಕ್ವಶನ್ ಸರ್. ಸರ್, ಈಗ ಎಕ್ಸಾಮ್ ಅಲ್ಲಿ ನಾವು ಯಾವ ರೀತಿ ಬರೀಬೇಕು ಸರ್ ಆನ್ಸರ್? ಜನರಲ್ ಕ್ವಶನ್ ಸರ್ ಆಕ್ಚುಲಿ. ಹಲೋ ಸರ್.
Sir, able to hear Mr. Vijay Kumar Bagoji voice, sir? Hello, Kantraj sir. I hope.
Hello sir.
Hello, ಹೇಳಿ
ಸರ್. ಧ್ವನಿ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್?
ಇವಾಗ ಹೇಳಿ, ಪರವಾಗಿಲ್ಲ.
ಬಾಗೋಜಿ ಅವರು ಹೇಳಿ.
ಜನರಲ್ ಕ್ವಶನ್ ಇದೆ ಸರ್ ಆಕ್ಚುಲಿ. ಇವಾಗ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಈಗ ಮೇನ್ ಎಕ್ಸಾಮ್ ಅಲ್ಲಿ ಆನ್ಸರ್ಸ್ ಯಾವ ರೀತಿ ಬರೀಬೇಕಾಗುತ್ತೆ ಸರ್? ಈಗ
ಸರ್, ಯಾವುದು ಜನರಲ್
ಕ್ವಶನ್ ಸರ್ ನಂದು. ಇವಾಗ ಕ್ವಶನ್ ಅಲ್ಲಿ ತ್ರೀ ಟೈಪ್ ಆಫ್ ಪ್ಯಾಟರ್ನ್ಸ್ ಇದೆ. ಒಂದು ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಬರುತ್ತೆ, ಒಂದು ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡೋದು ಬರುತ್ತೆ, ಒಂದು ಜಜ್ಮೆಂಟ್ ರೈಟಿಂಗ್ ಬರುತ್ತೆ. ನೆಕ್ಸ್ಟ್ 10 ಮಾರ್ಕ್ಸ್ ಕ್ವಶನ್ಸ್ ಇರುತ್ತೆ. ಅದನ್ನ ಯಾವ ರೀತಿ ನಾವು ಬರೀಬೇಕಾಗುತ್ತೆ? ವೆದರ್ ವಿ ನೀಡ್ ಟು ಸ್ಪೆಸಿಫೈ ದ ಲಾಸ್, ಕೇಸ್ ಲಾಸ್ ರೆಫರ್ ಮಾಡ್ಬೇಕಾಗತ್ತಾ, ಅಥವಾ ನಮಗೆ ಏನು ನಾಲೆಜ್ ಇದೆ ಅದ್ರ ಬಗ್ಗೆ ಒಂದು ಜಿಸ್ಟ್ ಆಗಿ ಬರೆದ್ರೆ ಆಗತ್ತಾ? ವೆದರ್
ಹೌದು, ನೀವು ಅಲ್ಲಲ್ಲ, ನನಗೆ ತಿಳಿದ ಮಟ್ಟಿಗೆ ನಾನು ಯಾವ ಜಡ್ಜ್ಗಳ ಎಕ್ಸಾಮ್ ನಾನು ಬರ್ದಿಲ್ಲ. ಬಟ್ ನನಗೆ ತಿಳಿದ ಮಟ್ಟಿಗೆ ಒಂದು ನೀವು ಆದಷ್ಟು ಸ್ಪೆಸಿಫೈ ಮಾಡಬೇಕು, ಬ್ರೀಫ್ ಆಗಿರ್ಬೇಕು. ಆಸ್ ಫಾರ್ ಆಸ್ ಪಾಸಿಬಲ್ ಈ ಟ್ರೈ ಟು ಮೆನ್ಷನ್ ದಿ provisions of law if you are definite about it.
Otherwise,
definite, and also the decision of the court if you are sure about it. So I think that will be appreciated by the evaluator.
Oh, thank you.
ಇಲ್ಲ ಕರೆಕ್ಟ್ ಇದು ಪ್ರಾವಿಷನ್ಸ್ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ.
ಸ್ಪೆಸಿಫಿಕ್ ಲಾನು ಗೊತ್ತಿದೆ ಬರಬಹುದು, ಬಟ್ ರೀಸೆಂಟ್ ಆಗಿ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಿಂಗಾಗಿದೆ ಅಂತ ಬರಿಬಹುದು ನಾವು.
Yes, ಬರಿಬಹುದು. You can cite and say give an example of the judgments also.
Yes sir.
Okay.
Thank you sir. Thank you.
ಭವ್ಯ ದೇವೇಂದ್ರ ಕುಮಾರ್ ಅವರು. ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಭವ್ಯ ದೇವೇಂದ್ರ ಕುಮಾರ್ ಅವರು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್.
ಸರ್, ನಮಸ್ತೆ ಸರ್. ಸರ್, ನಮಸ್ತೆ ಸರ್. ಭವ್ಯ ದೇವೇಂದ್ರ ಕುಮಾರ್ ಅಂತ, ಚಿತ್ರದುರ್ಗ ಬಾರಿಂದ. ಥ್ಯಾಂಕ್ ಯು ಫಾರ್ ವಂಡರ್ಫುಲ್ ಸೆಷನ್ ಸರ್. ನನ್ ಕ್ವಶನ್ ಬಂದ್ಬಿಟ್ಟು ಒಂದು 2016 ಕ್ವಶನ್ ಪೇಪರ್ ಅಲ್ಲೇ ಕೇಳಿದ್ರು. ಇನ್ ಎ ಸೂಟ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ದ ಡಿಫೆಂಡೆಂಟ್ ಟೇಕ್ಸ್ ದ ಸ್ಟ್ಯಾಂಡ್ ದಟ್ ಪ್ಲೇಂಟಿಫ್ ಇಸ್ ನಾಟ್ ಎ ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್. ಅದೊಂದು ಸ್ಟ್ಯಾಂಡ್ ತಗೊಂತಾನೆ, ಅಂದ್ರೆ ಅವನ ಅಗ್ರಿಕಲ್ಚರಲ್ ಇಷ್ಟ ಅಲ್ಲ. ಸೊ ಈಸ್ ಬಾರ್ಡ್ ಫ್ರಮ್ ಪರ್ಚೇಸಿಂಗ್ ದ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಅಂಡ್ ಈ ಎಸ್ಟಾಬ್ಲಿಷ್ ದಟ್ ಈಸ್ ಗ್ರೋಯಿಂಗ್ ಕಾಫಿ ಕ್ರಾಪ್ ಇನ್ ದ ಲ್ಯಾಂಡ್. ಈ ಟೈಮ್ ಅಲ್ಲಿ ಯಾವ ರೀತಿಯಾಗಿ ಇದು ಆಗುತ್ತೆ ಅಂತ ಸರ್?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಆಸ್ ಆನ್ ದಿ ಡೇಟ್ ಆಫ್ ದಿ ಅಗ್ರಿಮೆಂಟ್, ಸೊ ವಾಸ್ ಹಿ ಪ್ರಿವೆಂಟೆಡ್ ಫ್ರಮ್ ಟೇಕಿಂಗ್ ದಿ ಲ್ಯಾಂಡ್ ಆಸ್ ಆನ್ ದಿ ಡೇಟ್ ಆಫ್ ದಿ ಅಗ್ರಿಮೆಂಟ್? ಅಲ್ಲ, ಯು ಆರ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದಿ ಡಿಫೆಂಡೆಂಟ್ ಆರ್ ವಾಟ್?
No sir, this was the question which was asked in the examination sir.
ಹೇಳಿ ಅದು ಎಕ್ಸಾಮ್ ನಲ್ಲಿ. ಅಲ್ಲ, ಅದನ್ನ the only answer is according to me, so unless and until that agreement is valid, they are not entitled for the specific relief act. So when that agreement will be called void, if there is any provision of law in purchasing the land, maybe that is fragmentation of law, land irbeku.
Okay sir. ಅದೇ ನಾನ್ ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್ ಅಂತ
ಅಲ್ಲ, ನಾನ್ ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್ ಅಂತಂದ್ರೆ ಅಲ್ಲಿ ನಾನ್ ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್ ಕೆನಾಟ್ ಅಕ್ವೈರ್ ದಿ ಲ್ಯಾಂಡ್ ಅಂತ ಇದ್ರೆ ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಅಲ್ಲಿ his acquisition is illegal. It is like ಅದೇ ನಾನು ಹೇಳಿದ್ನಲ್ಲ, ಫ್ರಾಗ್ಮೆಂಟೇಶನ್ ಆಕ್ಟ್ ನೀವು ವಿತಿನ್ 2 acres ನೀವು ತಗೊಳಕ್ ಬರೋದಿಲ್ಲ ಅಂತಕ್ಕಂಥ ಲಾ ಇದ್ದಾಗ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಇಲ್ಲಿಗಲ್ ಅದು. ಆ ತರ ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಅಗ್ರಿಮೆಂಟ್ ಊರ್ಜಿತ ಆಗೋದಿಲ್ಲ.
ಓಕೆ ಸರ್. ಸೊ ಅದೇ ರೀತಿ ನಾವು ಬರೋದ್ರೆ ಆಯ್ತಲ್ಲ ಸರ್.
ಅಲ್ಲ ಅದಕ್ಕೆ ಆನ್ಸರ್ ಏನಂತ ಹೇಳಿದ್ರೆ, ಆನ್ಸರ್ ಏನಂತಂದ್ರೆ, if there is any prohibition for acquiring the land, so then the agreement or the contract was illegal.
Okay sir.
Then the purchaser will not be entitled to the land.
Okay sir. Thank you sir.
Because acquisition itself is illegal.
ಹೌದು ಸರ್. When the contract itself is illegal, he cannot enforce it.
Yes.
Okay sir. Thank you sir. Thank you very much.
Thanks Amma. Thank you very much. All the best.
Thank you sir.
ವೇದಿಕೆಯಲ್ಲಿ ಶಿವನಂಜುನವರು ಕೊನೆಯ ಪ್ರಶ್ನಾರ್ಥಿಗಳಾಗಿದ್ದಾರೆ. ಶಿವನಂಜುವರ ಧ್ವನಿಯನ್ನು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರಿ. ನಿಮ್ಮ ಯಾವ ಬಾರ್ ಅಂತ ಹೇಳಿ ಪ್ರಶ್ನೆ ಕೇಳಿ.
ಸರ್ ನಮಸ್ತೆ ಸರ್. ನಾನು ಶಿವನಂಜು ಸರ್, ಮಂಡ್ಯ ಬಾರ್.
ಧ್ವನಿಯನ್ನ ಒಂಚೂರು ಜೋರಾಗಿ ಮಾತಾಡಿದ್ರೆ ಕೇಳಿಸ್ತದೆ ನಿಮ್ಮ ಪ್ರಶ್ನೆ.
ಮಂಡ್ಯ ಬಾರಿಂದ ಸರ್.
ಎಸ್ ಕೇಳಿ ಸರ್ ನಿಮ್ಮ ಪ್ರಶ್ನೆ.
ಸರ್ ನಂದು ಕ್ವಶನ್ ಅಂತಂದ್ರೆ, ಒಂದು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ನಲ್ಲಿ ಟೋಟಲ್ ಮೆಜರ್ಮೆಂಟ್ ಬಂದು 20 ವರೆಗೆ ಉಂಟಾ ಸರ್ ಆಕ್ಚುಲಿ ಮೆಜರ್ಮೆಂಟ್ಸ್, ಬಟ್ ಡಿಜಿಟಲ್ ಸಂಖ್ಯೆಯಲ್ಲಿ 21 ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಸರ್.
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಒಂದು ಬರ್ದಿದ್ದಾರೆ.
ಹೌದು ಸರ್. ಟೋಟಲ್ ಅದು ಆಕ್ಚುಲಿ 20 ವರೆಗೆ ಉಂಟೆ ಆಸ್ತಿ ಅಗ್ರಿಮೆಂಟ್. ಹೇಳಿ
ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಹೇಳಿ, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಶಿವನಂಜು ಅವರೇ, ನೀವು ನಿಮ್ಮ ಸಿಸ್ಟಮ್ ಅನ್ನ ಒಂಚೂರು ಮುಂದ್ಗಡೆ ತಗೊಳ್ಳಿ, ಅಥವಾ ಫೋನ್ ಆಗಿದ್ರೆ ಆ ಸ್ಪೀಕರ್ ನ ಮೇಲೆ ಇಟ್ಕೊಳ್ಳಿ.
ಹಾಗಾಗಿ ಅದು 21 ವರೆಗೆ ಉಂಟೆ ಅಂತ ಡಿಜಿಟಲ್ ನಂಬರ್ ಆಗೋಗಿದೆ ಸರ್ ಆಕ್ಚುಲಿ.
ಎಲ್ಲಿ?
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಸರ್.
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ. ಓಕೆ.
ಹೌದು ಸರ್. ಅದು ಆಕ್ಚುಲಿ ಬಂದು 20 ವರೆಗೆ ಉಂಟೆ ಆಸ್ತಿ ಸರ್. ಅಕ್ಷರದಲ್ಲಿ 20 ವರೆಗೆ ಉಂಟೆ ಅಂತ ಇದೆ, ಡಿಜಿಟಲ್ ನಂಬರ್ 21 ವರೆಗೆ ಉಂಟೆ ಅಂತ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಅಲ್ಲ, ಅದನ್ನು ನೀವು ಅಮೆಂಡ್ಮೆಂಟ್ ಕೇಳ್ಬೇಕಷ್ಟೇ, ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ನೀವು ಚೇಂಜ್ ಕೇಳ್ತಾ ಇದೀರಿ ಅಂತ.
ಅಲ್ಲ, ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಆಗಿದೆ ಸರ್. ಹಾಗಾಗಿ ಸೂಟ್ ಬಂದಿಗೆ ಜಡ್ಜ್ಮೆಂಟ್.
ಅಲ್ಲ, ಅದನ್ನೇ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೀವು ಈಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಕೇಳ್ಕೊಂಡು ಅದನ್ನ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ಬೇಕು.
ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ
ಇಲ್ಲಾಂದ್ರೆ ನೀವು ಅದನ್ನ ಹೇಳಿದ್ನಲ್ಲ, ನಾ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಆಫ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಸೂಟ್ ಹಾಕೋಬೇಕು.
ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ
ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಅಲ್ಲಿ ತಪ್ಪಿದ್ರೆ
ಜಡ್ಜ್ಮೆಂಟ್ ಏನಾರು ಇದೆಯಾ ಸರ್? ಆಕ್ಚುಲಿ ಮೆಜರ್ಮೆಂಟ್ಸ್ ಕರೆಕ್ಟ್.
ಸೆಕ್ಷನ್ 31 ಅಷ್ಟೇ. 31 ವೆರಿ ಸ್ಪೆಸಿಫಿಕ್ ಅದು.
ಸೆಕ್ಷನ್ 31 ಸರ್.
ರೆಕ್ಟಿಫಿಕೇಶನ್ ಆಫ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್.
ಇದ್ರ ಬಗ್ಗೆ ಯಾವ್ದಾದ್ರು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಾ ಸರ್?
ರೈಟ್ ನಾವು ನನಗಿಲ್ಲಪ್ಪ, ನೀವು ಆಮೇಲೆ ಫೋನ್ ಮಾಡಿ ಕೊಡ್ತೇನೆ ಬೇಕಾರೆ.
ಎಸ್ ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಸೆಕ್ಷನ್ 31 ಅಲ್ಲಿ ನೋಡ್ಬಿಡಿ, ಅದು ವೆರಿ ಕ್ಲಿಯರ್ ಅದು.
ಎಸ್ ಸರ್.
ಸೆಕ್ಷನ್ 31 ಅಲ್ಲಿ
ಶಿವನಂಜು ಅವರು ಸೆಕ್ಷನ್ 31 ಅನ್ನ ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನಂತರದಲ್ಲಿ ಏನಾದರೂ ನಿಮಗೆ ಸಂದೇಹ ಇದ್ರೆ ಗೌರವಾನ್ವಿತರನ್ನ
ಫೋನ್ ಮಾಡೋದಕ್ಕೆ ಹೇಳಿ.
ಎಲ್ರಿಗೂ ಈಗಾಗಲೇ ನಾನು ಸಂದೇಶವನ್ನ ಕಳಿಸಿದ್ದೇನೆ. ಗೌರವಾನ್ವಿತರ ಫೋನ್ ನಂಬರ್ ಅನ್ನ ಅದರಲ್ಲಿ ಕಾಣಿಸಿದ್ದೇನೆ, ತಾವೆಲ್ಲ ಅದನ್ನ ನೋಟ್ ಮಾಡ್ಕೊಳ್ರಿ ಅಂತ ಹೇಳ್ತಾ, ಮತ್ತೋರ್ವ ಪ್ರಶ್ನಾರ್ಥಿಗಳು ಅಡ್ವೊಕೇಟ್ KM ಹಿರೇಮಠ ಅನ್ನೋರು, ದಯವಿಟ್ಟು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ನಿಮ್ಮ ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳಿ. ಯಾವ ಬಾರ್ ಅಂತ ಹೇಳಿ.
ಸರ್ ನಮಸ್ಕಾರ ರೀ, ನಾ ಬೆಳಗಾವಿ ಬಾರದಿಂದ ಮಾತಾಡೋದು ಸರ್.
ಥ್ಯಾಂಕ್ ಯು. ಹೇಳಿ
ಸರ್. ಸೆಕ್ಷನ್ 16C ಪ್ರಕಾರ ರೆಡಿನೆಸ್ ಅಂಡ್ ವಿಲ್ಲಿಂಗ್ನೆಸ್ ಸ್ಪೆಸಿಫಿಕಲಿ ಕ್ಲಿಯರ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಿ. ಆದ್ರೆ ಒಂದ್ ವೇಳೆ ಅದು ಕ್ಲಿಯರ್ ಮಾಡೋದನ್ನ ನಾವು ಬಿಟ್ಬಿಟ್ಟಿದ್ರೆ ಆಮೇಲೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಅದನ್ನ ಸೇರಿಸಬಹುದಾ ಸರ್?
ಇಲ್ಲ, ಅಲ್ಲಿ ಪ್ರಾವಿಷನ್ ಮಾಡಿಲ್ಲಮ್ಮ. ಅದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ವಜಾ ಮಾಡಬಹುದು ಅಂತ ಇದೆ. ಅದನ್ನೇ ನಾನು ಹೇಳಿದ್ದು. ILR 2006 ಕರ್ನಾಟಕ ಹೇಳಿದೀನಿ ನೋಡಿ, 1207. ಅದನ್ನೇ ಡಿಫರೆನ್ಸ್ ಸೆಕ್ಷನ್ 16C ಮತ್ತು 21
ಆತ್ಮೀಯ ಬಂಧುಗಳೇ,
ಓಕೆ ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಥ್ಯಾಂಕ್ಸ್ ಅಮ್ಮ.
ಇಲ್ಲಿಯವರೆಗೂ 2 ಗಂಟೆ 15 ನಿಮಿಷಗಳ ಕಾಲ ನಮ್ಮ ಈ KSBC ಲಾ ಅಕಾಡೆಮಿಯ ಈ ಒಂದು ಅಂತರ್ಜಾಲ ಉಪನ್ಯಾಸ ವೇದಿಕೆಯಲ್ಲಿ ಹಿಂದುಳಿದ ವರ್ಗಗಳ ಮಾಜಿ ಅಧ್ಯಕ್ಷರು, ಅಖಿಲ ಭಾರತ ವಕೀಲರ ಒಕ್ಕೂಟ ಐಲೂನ ರಾಜ್ಯ ನಾಯಕರು ಹಾಗೂ ಸದ್ಯ ಹಿರಿಯ ವಕೀಲರಾಗಿ ಸಾಮಾಜಿಕ ಕಾಳಜಿಯನ್ನು ಹೊಂದಿರತಕ್ಕಂತ ಗೌರವಾನ್ವಿತರು ಇವತ್ತು KSBCಯ ಲಾ ಅಕಾಡೆಮಿಯ ಒಂದು ವಿನಂತಿಯನ್ನು ಒಪ್ಪಿಕೊಂಡು ಈ ವೇದಿಕೆಯಲ್ಲಿ ಬಂದು ನಮಗೆ ಸಾಕಷ್ಟು ಅನುಭವದ ಅಮೃತವನ್ನ ಈ ವೇದಿಕೆಯಲ್ಲಿ ನಮ್ಮೆಲ್ಲರಿಗೂ ಗುಣಪಡಿಸಿದ್ದಾರೆ. ಅಂತಹ ಗೌರವಾನ್ವಿತರಿಗೆ ಈಗ ವೋಟ್ ಆಫ್ ಥ್ಯಾಂಕ್ಸ್ ನೀಡಲಿಕ್ಕೆ ನಾನು KSBCಯ ಸದಸ್ಯರು ಹಾಗೂ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಆಫ್ ಇಂಡಿಯಾದ ಶಿಸ್ತು ಸಮಿತಿಯ ಸದಸ್ಯರಾಗಿರ್ತಕ್ಕಂಥ ಕೋಟೇಶ್ವರ ಸರ್ನ ವಿನಂತಿಸ್ತಾ ಇದ್ದೇನೆ. ಕೋಟೇಶ್ವರ ಸರ್ ದಯವಿಟ್ಟು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಎಸ್ ಪ್ಲೀಸ್ ಸರ್. ಸರ್ ವೋಟ್ ಆಫ್ ಥ್ಯಾಂಕ್ಸ್ ಅನ್ನ ನೀಡಿ.
Good evening, everybody. A special thanks to Mr. Kantaraj, a designated senior of the Karnataka High Court. He has given a wonderful lecture on the Specific Relief Act, along with the new amendments which was taken place recently. I also thankful to all the participants who has participated and gained the knowledge. It will be useful to the tomorrow's your exams, district judge exams. And I also thankful all the participants, one and all. Thank you. Thank you, one and all.
Thank you. Thank you very much.
Thank you so much. Thank you, sir. ಅದೇ ರೀತಿ ಈ ವೇದಿಕೆಯಲ್ಲಿ ಭಾಗವಹಿಸಿರ್ತಕ್ಕಂಥ ಎಲ್ರಿಗೂ ಧನ್ಯವಾದಗಳನ್ನು ಹೇಳೋದ್ರ ಜೊತೆಗೆ ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮವನ್ನ ಯೂಟ್ಯೂಬ್ ನಲ್ಲಿ KSBC ಲಾ ಅಕಾಡೆಮಿಯ ಯೂಟ್ಯೂಬ್ ನಲ್ಲಿ ಯಾರೆಲ್ಲ ವೀಕ್ಷಣೆ ಮಾಡ್ತಿದಾರೋ ಅವರೆಲ್ಲರಿಗೂ ಸಹಿತ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ KSBC ಲಾ ಪರವಾಗಿ ತುಂಬ ಧನ್ಯವಾದಗಳನ್ನು ತಿಳಿಸ್ತಾ ನಾಳೆ ಸರಿಯಾಗಿ 6 ಗಂಟೆ ಈ ವೇದಿಕೆಯಲ್ಲಿ ಮತ್ತೋರ್ವ ಗೌರವಾನ್ವಿತ ಅತಿಥಿಗಳ ಉಪನ್ಯಾಸ ಇರ್ತದೆ. ಸರಿಯಾಗಿ 6 ಗಂಟೆಗೆ ಎಲ್ಲರೂ ಹೆಚ್ಚಿನ ಸಂಖ್ಯೆಯಲ್ಲಿ ಭಾಗವಹಿಸಬೇಕು ಅನ್ನುವಂತ ವಿನಂತಿಯನ್ನ ಮಾಡ್ತಾ ಗೌರವಾನ್ವಿತರ ಈಗಾಗಲೇ ಸಂಪರ್ಕ ನಂಬರ್ ನಾನು ತಮಗೆ ನೀಡಿದ್ದೇನೆ. ಯಾರಿಗೆಲ್ಲ ಸಂದೇಹಗಳಿದಾವೆ ಅದನ್ನ ತಾವು ಫೋನ್ ಮುಖಾಂತರ ಸಹಿತ ಗೌರವಾನ್ವಿತರನ್ನ ಸಂಪರ್ಕ ಮಾಡಿ ನೀವು ಮಾಹಿತಿಯನ್ನ ಹೆಚ್ಚಿನ ವಿಷಯಗಳನ್ನ ತಿಳ್ಕೊಳ್ಳಿಕ್ಕೆ ಸಾಧ್ಯ ಇದೆ ಅನ್ನುವಂತ ಮಾಹಿತಿಯನ್ನ ನೀಡ್ತಾ ಎಲ್ರಿಗೂ ಶುಭವಾಗಲಿ, ಶುಭರಾತ್ರಿ. ಮತ್ತೆ ನಾಳೆ ಸಾಯಂಕಾಲ 6 ಗಂಟೆಗೆ ಇದೇ ವೇದಿಕೆಯಲ್ಲಿ ಸೇರೋಣ.
Sir, thank you, sir.
Thank you, Padma Madam ji.
Thank you, sir.